kind of a full plate of public hearings today. So we're live streamed, so we'll start with committee introductions, and I'm just going to call on committee members, and we'll start with you, Senator Keim.
Good morning, everyone. My name is Lisa Keim, and I'm proud to represent Senate District 18, which is Northern Oxford County, and 2 communities in Androscoggin.
Representative Reckitt.
Morning. I'm happy to be here and breathing. Anyway, I represent District 31, which is the ocean end of South Portland, and I'm happy to do so.
Representative Thorne.
Good morning from Carmel. I'm Representative Jim Thorne. I represent the Penobscot County towns of Carmel, Herman, and a portion of Etna. Happy Friday.
Representative Babbage.
Yes, good morning. My name is Christopher Babbage. I represent House District 8, which is about 82% of the voters of Kennebunk.
And Representative Moriarty.
Good morning, all. I'm Steve Moriarty, representing Cumberland and the southern part of Gray in House District 45.
And Co-Chair Harnett.
Good morning, Madam Chair and colleagues on the Judiciary Committee and members of the public. My name is Tom Harnett. I represent House District 83, which includes the town of Farmingdale and my hometown of the city of Gardner.
Thank you. And I'm Senator Ann Carney. I represent District 29, which includes South Portland, Cape Elizabeth, and a little bit of Scarborough. And we are joined today by our OPLA analysts, Janet Stocco and Peggy Reinsch, and also by our committee clerk, Susan Panett. And I'll tell you, everybody, the order of bills today, because it's a little different than how they were listed in order to accommodate legislators' other schedules. We're going to start with LD 1581, presented by Senator Searway, and then 1774, presented by Representative Harnett. Next will be LD 1804, Representative Roberts, and we'll conclude with 1786, which is a bill that I've sponsored. So that's the order. And with that, I am going to bring Senator Searway onto the panel to present his bill. Let's see if yes, there he is. Okay. Welcome, Senator Searway, and this will open the public hearing on LD 1581, an act to require telecommunication companies to divulge location information to law enforcement when necessary to respond to 911 calls or locate a person in danger. And you may begin whenever you're ready, Senator.
Thank you, and good morning. Good morning, Senator Carney, Representative Harnett, and members of the Judiciary Committee. I am Senator Scott Searway, and I am here before you today to present LD 1581, an act to require telecommunications companies to divulge location information to law enforcement when necessary to respond to a 911 call or locate a person in danger. It's too early in the morning. Ultimately known as the Kelsey Smith Act. I was contacted last January by Missy Smith, the mother of the young lady who this legislation is named after. On June 2nd, 2007, 18-year-old Kelsey was abducted in broad daylight from Target parking lot in Kansas. When law enforcement requested the pinpointed location of Kelsey's phone from her cell phone provider, they would not disclose it. In this particular case, a subpoena was made. However, information was not provided soon enough, and when the cell phone's location was finally given, it took authorities just 45 minutes to locate Kelsey, and very sadly, it was too late. The young lady was with so much life still to live, had been raped and murdered. As stated in the title, this legislation would provide law enforcement with a way to quickly obtain the location of a wireless device if a person has been determined by law enforcement as being at risk of serious harm or death. The bill would also provide immunity to the telecommunications service provider from any civil or administrative proceedings by a government entity for providing information. If this had been in law in 2007, it is quite likely that Kelsey's life could have been saved. I know from my personal experience that being able to obtain this information could have aided me and my fellow law enforcement colleagues to save a life of a young lady who was killed right here in Augusta. It also could have helped me to locate a suicidal individual in the woods and help them get the support they needed much faster. To date, Kelsey Smith's legislation has become law in 30 states and is already helping to address life-threatening situations across the country. I strongly urge you to support of this meaningful and proactive legislation that I will undoubtedly help save lives of endangered and suicidal persons. Thank you for your time, and I would be happy to answer any questions you may have.
Thank you very much, Senator Searway. Committee members, are there questions? And I see we do have some questions. Go ahead, Representative Evangelos.
Thank you, Madam Chair. Good morning, Senator Seaway.
Good morning.
I just have a very quick question. Have you had the proposal analyzed legally in terms of Fourth Amendment protections?
Yes, this has gone through, like I said, 30 states has already approved it, and it has, and actually, I believe the PUC is going to probably put in some input today of it's basically just for the location. It's not going into their past or anything, or all the history or anything. It's just location because of the danger that's going on. So it really is more a life or death situation to just find the person. So that's all it is.
Representative Thorne, go ahead with your question.
Thank you, Madam Chair. Senator Searway, welcome. Thank you for bringing this legislation forward. My question, last fall, I had a vehicle right behind my house. There's a dirt road. And there was a vehicle back there, and I thought they maybe just got stuck and were going up hunting. After a while, I did go out and I looked at it, and there didn't appear to be anybody in the vehicle. I didn't go right up to the window, but stayed out there. And I thought about it, and I did call the sheriff's department to report it, just in case somebody had stolen the vehicle. Well, while I was out on the main part of the road and a sheriff's deputy rolled up, another vehicle rolled up, and it was the mother of the young lady, and they had followed, somehow they had a locator on their phone that followed her phone. And come to find out, she was in the vehicle and she was suicidal. And they went up and got the young lady out of the vehicle who had got stuck, but more than likely she was going up back for that same reason. And my question to you is, what's the difference between a mother being able to track a daughter on the phone? Is that because she owns the phone? That's the only way that she's allowed to track it? Or is there currently anything forbidding that presently?
Well, I think there may have been an app or something that maybe she had for her kids. I don't know. But I will say that right now, as the way the law is written, it kind of is a little bit, it kind of allows this, but it says may instead of shall. And so what happens is there may be some phone companies will allow it and some won't. And we're just trying to eliminate that question because all it takes is just once to try to get somebody, and you can't, and they won't allow it because there's just some question in their mind saying, we can't do this. And that can delay, it's a time sensitive situation. And so this is just trying to clarify that. And I think, it hits the home for me. So, yeah.
Thank you. Thank you,
Senator-
Madam.
You're welcome. Senator Kime?
Thank you. Good morning, Senator Searway. I was wondering, you were just talking about how our current law says may obtain, and I'm wondering if, so I guess I read that a little bit differently, so I wanted to ask your opinion, but how I'm reading it is that the government entity may choose to obtain that location information or may not, depending on whether or not they feel it's reasonable or necessary, not that the entity itself that holds the location. I didn't see the may as whether or not they decided to oblige the government entity that was asking for the information. Do you understand my question?
I do.
Okay.
And so, and that when they say that it may, it really puts that question mark, just like you're asking, in a sense, because they may read it differently than you do, as saying, well, maybe you have to get a subpoena because I'm not sure on this and I'm not going to take a chance. And this eliminates the responsibility put onto the telecommunications people for the location. So, but PUC, you could ask that same question probably to the PUC, and they said that there's like two places that's kind of confusing, and so that there is a way to clear that up. So that's
Okay.
what, and I'd be more than happy for the PUC to amend that if it has to be.
Okay,
So
thank you.
Yeah.
All
Hope
right,
that
thank you.
helps. Yeah.
Committee members, any other questions? Senator Searway, a quick question for you. You had referenced a couple of times the PUC, and I don't see anyone from the PUC signed up to testify this morning. And I'm just wondering if perhaps they're in the waiting room to testify, but not signed up in advance. Can you let us know who you spoke to?
It's Deidre Schneider from Legislative Liaison for Maine Public Utilities Commission.
Okay, that's
She's got,
helpful.
actually, she's got a thing that she sent you, maybe the written testimony that she was going to get.
Okay,
And
thank you
she'll
very much.
probably be on the neither for nor against, but she'll probably send, she sent that to you, I believe.
Okay, great. That's super helpful. Thank you.
Yeah.
Committee members, any other questions for the bill sponsor? Go ahead, Representative Babbage.
Thank you, and good morning.
Good morning.
Senator Searway. Thank you for this discussion. Can I ask you if, and I don't know who maybe else may be speaking this morning, but regarding the fact that 30 states have passed the Kelsey Smith law, from my reading of this, the threshold for this to happen would be reasonable suspicion. I wondered if you had any knowledge that the rest of the states that have adopted this have that same threshold or have adopted a different threshold as far as.
I believe it is. And you know, there's situations where, you know, when you say reasonable suspicion, it might be where family members may say, geez, he's been talking like he's been thinking about suicidal tendencies and he's been missing this such and such a long length of time, and it might be unusual circumstances. And so that might be enough to be considered reasonable suspicion there may be a danger. And so that might be enough just to find the location and just check on them. So I think that's where they're looking at is, and then there's some that's very serious cases that they really know, and I had one of those where it was a double homicide, and we had arsonist. It was a very serious case, and it was a 16-year-old we found, and yeah.
Okay, thank you.
Senator Khan?
Thank you. It's not a question. I just wanted to clarify for the committee that I heard that that Deidre Snyder is not going to come testify. She did, of course, submit testimony to us. So I guess if there are specific questions we have for them, we'll have to just get it for the work session, just so everyone's aware. Thank you.
Thank you.
Representative Moriarty?
Thank you, Madam Chair. Good morning, Senator Sirway. I just wanted to confirm my reading of your bill. It seems as though there are two situations in which the information must be turned over by the provider. The first being the actual placement of a 911 call from the device, and the second one being a reasonable suspicion that the device's owner or possessor is in danger. Have I read that correctly?
Yes.
Okay, that's good. This looks really tight, and I'm glad you've introduced the bill.
Thank you.
Representative Babbage? No, okay.
Yeah, thank you.
All right. Okay, so I'll go ahead, Representative Harnett.
Thank you. And it's just a technical question. I am not seeing testimony from Ms. Schneider in the portal, so I don't.
Yeah,
We're hearing that it's been submitted. I've not seen anything.
Yeah, she spoke with our committee clerk and said she'd be submitting a letter. And
okay,
yeah,
thank you.
Yeah, thank you. Go ahead, Representative Sheehan.
Thanks, Madam Chair. I do see the written testimony in the portal, so I can send it into the chat. Is that?
It's okay.
Okay.
Any more questions for the bill sponsor? I am not seeing any. Thank you, Senator Searway. And we do allow bill sponsors to stay on the panel if they wish. And so you're welcome to stay during the testimony.
Can I say one comment? Just,
Yes, go ahead.
I would say that also the National Sheriff's Association has endorsed this as well. Just
Thank
so
you.
know. Thank you.
All right, and so now we'll turn to the testimony on this legislation. And I just want to remind everybody who's going to be testifying that we do run a 3-minute clock so that we hear from each of the people who want to speak to the bill and have adequate time for questions and answers from committee members. And so I'm going to raise my electronic hand so that I stay in the corner of the screen, and then I'll hold up the clock as we get closer to the 3-minute time frame. And Representative Sheehan, did you have a question? No, okay. All right, and so I'm turning to those in the attendee space and asking everyone who's here who wishes to speak in favor of LD 1581 to please raise your electronic hand and keep it raised until you've provided your testimony. And let's see, okay. So we'll start with Missy Smith and then Greg Smith and then Sarah Carlson and then Major Ross. They'll all be coming over to the panel.
Sorry about that.
No, thank you, Missy Smith. It takes a little while to go from attendee to panelist.
Yes, ma'am.
Welcome to the Judiciary Committee, and you may proceed with your testimony when you're ready.
Yes, ma'am. Good morning, Chair Carney, Representative Harnett, and members of the Judiciary Committee. I am Missy Smith. I am the mother of Kelsey, and I am here to speak in favor of LD 1581. Along with my testimony today, I included for you a packet regarding the Kelsey Smith Act. I uploaded that so you would have information regarding where it is at across the nation. On June 2nd, 2007, Kelsey was abducted in broad daylight from a Target parking lot here in Kansas, just minutes from our home. Over the course of the next 4 days, a massive search for our daughter began by family, friends, and complete strangers. Her case included law enforcement of over 120 detectives, multiple municipalities, 2 states, federal agencies, and even the FBI director. Kelsey's case drew national and international coverage. Almost from the beginning of her abduction, we started on the quest of trying to get her location information to no avail. After her body was recovered, I told my husband that it either takes lawsuits or legislation to get large corporations to act, and we now have the Kelsey Smith Act in 30 states. Just a few weeks ago, we were in my home state of Iowa speaking at a conference. We had several law enforcement officers tell us that they had used the law there. They didn't know why they had that law, but when using it, they were able to save lives, and they thanked us for that. It has been used to save elderly stroke victims here in Kansas, prevent suicides, and rescue a child from a sexual predator in Tennessee. Please help us add Maine to our list of successes. Thank you for your time, and I am happy to answer any questions you may have.
Thank you very much, Missy Smith, and we are very sorry for your loss and
Thank you.
appreciative of your activism. Committee members, are there questions for Missy Smith? I'm not seeing any. Once again, thank you for providing testimony today. And then the next panelist we'll hear from is Greg Smith. Thank you for appearing today, Greg Smith, and you can begin when you're ready. We are not able to hear you.
I was on mute. I'm sorry.
Okay.
Well, good morning, Madam Chair, members of the committee. Thank you for allowing me this opportunity to testify. My wife told you the story of what happened and what our motivation is behind the Kelsey Smith Act. Let me go more into the legal provisions of what exists around the United States right now. I'm a deputy sheriff here in Kansas and fairly familiar with this. I am trained in cell phone mapping and all of that type of stuff. But there are 2 federal controlling laws right now when it comes to communications. You have the Electronic Communications Privacy Act and the Telecommunications Act of 1934. Both of those allow for voluntary disclosure by a cell phone provider to give that location information if the cell phone provider feels that that person is at risk of bodily harm or death, or if they have evidence of a crime, maybe that they came across, that the provider came across, they can voluntarily disclose that information. The problem with that is you have a provider who doesn't have the information that law enforcement has, trying to make a decision on whether or not this is a life or death situation. This is exactly what happened in my daughter's case. When Kelsey was missing, they just kept saying, you know, we don't know what's going on. We can't release this right now. And the police had the information, submitted proper legal paperwork, and it took 4 days to get that information. And my daughter was found, her body was found within 45 minutes once we got the information. So the need for this is fairly clear. Right now, it's totally voluntary on the companies on whether or not they have to give that information up or not. So why not flip the paradigm? Law enforcement's trained on what an emergency is. Cell phone providers are not necessarily. I can tell you that our experience during when Kelsey was missing, talking with the cell phone company, us and law enforcement, they tried to upgrade our cell phone plan. That's not what I needed right then. I didn't need more minutes. I needed to know where my daughter was. Now, the Communications Act of 1934 provides the exception for disclosing information if the caller has made a 911 call. So if they don't make that call, that act's not even, it doesn't even come into play. The ECPA, the Electronic Communications Act, does allow voluntary release in an emergency situation, but again, it's totally up to the provider. It's not up to law enforcement. So what the Kelsey-Smith Act does is it flips the paradigm and it gives law enforcement that decision-making process. I heard a question asked earlier where is reasonable suspicion the standard? Yes, it is. I'm also a former legislator in Kansas, and I know that every legislator is concerned about cost. I can tell you that in every state, the fiscal note for this bill has been zero. There is a savings, though. There's a lot of savings of life. So thank you very much.
Thank you very much, Mr. Smith, for your testimony, and we're sorry for your loss. Committee members, I see that there are a couple of questions for Mr. Smith. Go ahead, Representative Thorne.
Thank you, Madam Chair. Welcome to the Judiciary Committee here in Maine, Mr. Smith. We appreciate you bringing this forward. Seems like a very worthwhile bill. You may have some working knowledge of what the process is, and I'm just for my own clarifications. Once this is enacted, you would be able to go to the police department, report that your daughter is missing, overdue, and is there any check with the telephone company from the police department as far as authorizing it, or it's just instantaneous? They call and the information is immediately released without question.
Thank you, Representative Thorne, for the question. It is not necessarily instantaneous. It's very, very quick, but there are protocols in place where identities of the people making those requests are verified by the cell phone provider. So it's not just anybody in the world can call the cell phone provider and say, hey, we're so-and-so. But those protocols, I can't talk about in public committee.
Okay, thank you. Thank you, Madam Chair.
Committee members, any other questions? Not seeing any. Oh, go ahead, Representative Harnett.
Thank you, Madam Chair, and thank you, Mr. Smith, for being here today. Very sorry for your loss and understand your passion for this issue. Representative Evangelos raised the question to the bill sponsor regarding the Fourth Amendment. I think I heard that this bill has been enacted, or versions of this bill have been enacted in 30 states. Are you aware of any challenges to those laws on constitutional grounds? And if so, do you know what happened in those cases?
To my knowledge, there has only been one constitutional challenge to the law. It took place in Missouri, and the case was dismissed. To be quite frank, there are certain entities that usually are in opposition to the bill on privacy issues. I want to make it very clear that the Kelsey-Smith Act does not allow the release of anything off of that phone other than geographical coordinates. That's it. Nothing else. No pictures, no conversations, no history, nothing. It's simply, we need a location to go to make sure that this person is okay. And that's all it does. I know here in Kansas, we've had, we call them saves, suicidal subjects that we've located prior to them being able to complete that act. Missing children. We had a baby that was taken during a carjacking. The mother's purse was in the car with her cell phone in the car. The car and the baby were relocated within 20 minutes due to the Kelsey-Smith Act. It's life-saving legislation and when you weigh the risk of intrusion or search per se, compared to the good that comes out of it, it's a very minimal risk.
Thank you very much, sir.
Don't see any additional questions. Mr. Smith, once again, thank you for appearing before the committee.
Thank you, Madam Chair.
And next we'll hear from Sarah Carlson. And Sarah, you may begin when you're ready.
Thank you, Mr. Chairman, Madam Chairwoman, members of the committee. It's an honor to be here. My name is Sarah Carlson. I'm president and founder of the Katy Porter Legislative Coalition for Victims' Rights. I'm here today to speak on behalf of my support for LD 1581. LD 1581, known as the Kelsey Smith Act, would require that cell phone companies hand over cell phone location records to law enforcement when people's lives are in danger for the purpose of finding them and saving their lives. When people are missing and in danger of bodily harm, it is our duty to do everything humanly possible to find them and save their lives. To do otherwise is cruel and inhumane. This bill is not designed for the police to find criminals. It's designed for the police to find people who are in grave danger and bodily harm, and there are safeguards to make sure that the bill is not abused. When a person is missing and in grave danger, seconds counts when it comes to finding them and saving their lives. Their family and friends are panicking and scared to death for their loved one's safety. For the person who is missing in grave danger, they are praying desperately for someone to come and save them. No person should have to lose their life and not have someone save them because of a technicality. So far in the states where the Kelsey Smith Act has been enacted and saved lives, it has been saved lives. No one ever once has it ever been misused by the police. It saved the life of a 19-year-old young woman in Utah about a month ago. Madeline Allen is a college student who was kidnapped. Police were able to find her through her cell phone location, and she was rescued and is now safe with her family. Back in 2014, it also saved the life of a 2-year-old boy in Minnesota. A father had stopped at a gas station with his 2-year-old son in the back seat of the car. The father stepped away from the car to say hi to an acquaintance. A thief then got to the father's car and drove away with the 2-year-old boy in it. Because the father's cell phone was in the car, police were able to ping the location of the stolen vehicle, and 30 minutes later, the vehicle was found with the child safe and sound. I never had the chance to know Kelsey, but I know her parents. They are wonderful people, and Kelsey nor her family deserve to go through what they did, nor should any family ever have to go through that. Therefore, I ask you to vote yes on this legislation.
Thank you very much, Sarah Carlson. And in the Maine legislature, we ask folks who testify before a committee to not only introduce themselves, but to let us know their hometown and state. Could you please include
From
that?
St. Paul, Minnesota.
St. Paul, thank you very much. Committee members, are there any questions for Sarah Carlson? Not seeing any. Thank you so much for your testimony today.
Thank you.
And next we'll hear from Major William Ross.
Thank you and good morning, everyone.
Good morning.
Senator Carney, Representative Harnett, and distinguished members of the Judiciary Committee. My name is Major William Ross. I'm here to represent the Department of Public Safety and the Maine State Police to testify in favor of LD 1581, an act to require telecommunications companies to divulge location information to law enforcement when necessary to respond to a 911 call or locate a person in danger. The proposed legislation appears to be an effort to bring existing Maine law and the Kelsey Smith Act together by streamlining the process of obtaining location data from telecommunications companies. The tragedy of Kelsey Smith's death and the circumstances surrounding the immediate investigation prompted questions as to how the existing system or process can function more effectively and efficiently. In the late 2000s and into 2010s, cell phone and/or smartphone technologies were rapidly changing society, and public safety's efforts to keep up presented a challenge. The ability to obtain location data from a cell phone is critical to first responders and investigators in finding the person who needs help. For several years, the delay in obtaining location data was a problem for law enforcement and other first responders. Public safety in Maine, specifically the Department of Public Safety and the Maine State Police, have not experienced these issues regarding a delay in obtaining location data from telecommunication companies in recent years. Exceptions to the warrant requirement give Maine law enforcement the legal grounds to get location data through requests from our dispatch centers. The 3 regional communication centers operated by the Department of Public Safety, Augusta, Bangor, and Holton, all concur the past issues regarding the timeliness of obtaining the location data have been reconciled for some time. The proposed legislation in Maine law would need to reconcile language and ensure the process remained free of obstacles which would impede first responders' efforts in obtaining the location data when timeliness is of the essence. Safeguarding the process of obtaining this critical information during an emergency is what the Kelsey-Smith Act has accomplished in several states throughout our country. This proposed legislation reinforces existing Maine law and could help ensure tragedies of the past are not repeated. For these reasons, I strongly urge the committee to vote out to pass on this bill. On behalf of the Department of Public Safety and the Maine State Police, I thank you for your time. Would be happy to try and answer questions that you might have.
Thank you very much, Major Ross, and we will have some questions for you. Representative Thorne, you can go ahead with your question.
Thank you, Madam Chair. Welcome, Major Ross. Is there any language that you've seen in the bill that needs to be changed, or in your opinion, does the language satisfy your need for allowing for immediate release?
Thank you for the question, Representative Thorne. In my opinion, and again, I'm not the legal mind, but with my experience, I would say that certainly the language would have to be reconciled so it's consistent with Maine law. And that would be a process certainly that would need to occur before anything would move forward. I don't think you can just merge these 2 things together right off the bat, but once that reconciliation process occurs, and that would take some time, then I think that the Maine law and the Kelsey-Smith Act, those 2 pieces of legislation are very similar.
Thank you. Thank you, Madam Chair.
Thank you for the question, Representative Thorne. Any other questions, committee members?
Yes.
Representative Babbage, go ahead.
Thank you, Madam Chair. Thank you, Major Ross, for your testimony. Could you take us through the process of here in Maine regarding what is currently happening regarding the need to do a warrantless connection?
From the law enforcement side, the exceptions to a search warrant for this type of information, you would need something like a 911 call where we weren't able to have contact with the individual on the other end of the line. And then the other part of it would be if it was someone was in some type of danger where, you know, they've physical harm or death, and there was reasonable suspicion that that type of incident had occurred. And that could be anything from a criminal investigation, like some of our homicides, right to a motor vehicle crash where maybe we have a car, but we don't have an individual located, and anything in between. Human trafficking plays a role into this as well. I don't want to get into the details of exactly what we do, but essentially what would happen is when we get to that point where we meet those types of requirements outside of a search warrant, those exceptions, then we act on that and we make a request to our communication centers, and they would subpoena that location information. And it's worked very well in recent years. It was a problem quite some time ago, but now it seems to have reconciled itself. We get that information, and oftentimes we're able to find the phone, and hopefully there's somebody with it.
Yeah, and if I may follow up, Madam Chair,
Yes.
what I'm trying to understand is that I realize that in subsection 650 in statute, warrant exceptions include consent of the owner, consent of a family member, or danger of death or serious injury. But I wanted to know, how does that translate in the decision-making that qualifies? Who does that within the department?
So if you're talking about the first and I think the fourth exception, the consent pieces aside, that would be the either the officer that is investigating or responding to that incident, or potentially a supervisor would make that determination that we have a problem, we need to locate this individual, and does it meet those requirements? Then the request is made through our communications center, and the communications center then reaches out to the telecommunications company and makes a request for that location data. So it would be people on scene that would make that determination. And, typically there would be a supervisor involved in that decision making.
And so if I can just clarify, if somebody is in the field, is it a supervisor at the communications center that would give the authorization, or is the authorization made in the field and the communications center is merely the conduit to get the information?
Well, I think in some instances it can be both. I think there's a kind of a safety net with the communications center. They have certain criteria they have to meet, which is the same criteria we do. So if you have an officer that's making a request that doesn't meet the right criteria, then it would probably be stopped there at the communications center. But typically that's something that's vetted out fairly well in the field. And they're usually very obvious circumstances where these exceptions come into play. They're very pronounced. Very infrequently would you have even a discussion as to whether or not this would something that would pass those hurdles. But certainly the communication centers have supervisors, and they would be making that request. And then at the other end, you have the telecommunications company then has to make sure that it meets their standards as well.
And if this legislation were to pass before us, how would anything change in current practice?
I don't think anything would change in the current practice. It works well right now. So when we were looking at this bill, it wasn't that we have a problem. And it's, is it more of a symbolic gesture? Is it something that can add a little bit more or more substance to what the law is? And that's kind of how we looked at it. Presently, right now, we don't have an issue making these requests through our regional communication centers, and we don't have any problem getting information immediately from the telecommunication companies.
Thank you for your testimony. Thank you, Madam Chair.
You're welcome. And Representative Poirier, go ahead.
Thank you, Madam Chair, and thank you for being with us today, Major Ross. My question, just to piggyback on the questions you just had, is with this legislation, would there be any time savings versus the process that you go through now? Because obviously in an emergency situation, time is of the essence.
Thank you for that question. I think that the process we have now, the timeliness of it is not a problem. It's not an issue right now. So I don't know if anything would improve on that. And I don't think the legislation is suggesting that it would improve it significantly. So my testimony was that, we have come a long way from the 2000s and 2010s when this was a significant problem. But I think with everybody having some type of a device, cell phone, smartphone in this day and age, it's really streamlined the process. So timeliness is not an issue. And I don't think that there would be anything in this bill that would increase that.
Okay, thank you.
Committee members, are there any other questions for Major Ross? I am not seeing any. Major Ross, thank you for being here, and we'll probably look to you at the work session as well.
Thank you.
And then I want to just turn to the attendee space and ask once again, is there anyone in the attendee space who wishes to testify in favor of this legislation who has not yet spoken? Please raise your electronic hand and keep it raised. And I am not seeing anyone, so we'll move to those who wish to speak against the legislation? And if so, please raise your hand and leave it raised. We have one person, Michael Kebita, who wishes to testify, so he will be with us momentarily. And while he's joining the panel, if there is anyone in the attendee space who wishes to testify neither for nor against on 1581, please raise your hand and keep it raised, and we'll get to you soon. And Mr. Kebita, thank you for joining us today. You can proceed with your testimony when you're ready.
Thank you very much, Senator Carney, Representative Harnett, and distinguished members of the Judiciary Committee. Good morning. My name is Michael Kebita, and I am here representing the American Civil Liberties Union of Maine as its policy council. We are a statewide organization committed to advancing and preserving the rights guaranteed in our state and federal constitutions. On behalf of our members, we first wish to express our condolences to the family members of Kelsey Smith. What happened to her was tragic and unthinkable. We urge this committee to oppose this bill because we believe that it is completely unnecessary and would needlessly expand a very important protection of our constitutional right against unreasonable searches and seizures. There is, as you've heard, already an exception to the warrant requirement in our laws, allowing law enforcement to obtain a 911 caller's location information without getting a warrant. The only thing this bill would change is that the telecommunications company would be required to agree with the law enforcement officer's assessment that there is indeed an emergency, justifying a warrantless disclosure of location information. We see no need for this expansion of the warrant requirement in Maine, mainly because there seems to be no Maine-specific event justifying such an expansion, and because the warrant requirement is an important safeguard of our constitutional right against unreasonable searches and seizures. Indeed, this bill has clearly originated from a national movement that is rooted in outdated practices of cell phone companies. Major William Ross of the Maine State Police just testified to you that there is no problem in Maine getting information from cell phone companies. He said it works well right now. We urge the committee to be cautious about enacting laws based on national laws that sweep the country when the laws of Maine seem to already provide protection. We want to warn the committee that any expansion of our rights carries a risk of abuse from the government. For those reasons, we urge you to vote ought not to pass, and thank you for your time and attention.
Thank you. Committee members, are there any questions for Michael Kebita? Go ahead, Representative Moriarty.
Thank you, Madam Chair. Mr. Kebita, I'm not a constitutional scholar, but I want to know from your point of view, when we're speaking about the location of a cell phone and nothing more, what in your view is being either searched or seized if the location of that device is disclosed to law enforcement?
Location is a very important part of one's right to privacy, which the United States Supreme Court has recognized as part of the Fourth Amendment right to be free of unreasonable searches and seizures. The most thorough discussion that I think the United States Supreme Court has engaged on in this issue is from the case United States versus Carpenter. You can easily Google it and download and read it. That decision involved the balance between privacy and security. It wasn't similar to the scenario that motivates this bill. In that case, the United States Supreme Court was deciding whether law enforcement should be allowed to get cell phone location information of people who had been arrested after committing a crime. So for investigative purposes, for the purpose of solving a crime. Here, there's an ongoing emergency, and location information is sought to save a life. To your question, what is being searched, what is being seized, what's being infringed? Arguably incredibly important facts about your life. Let's say you have an abusive partner who you don't want to know where you are. Or let's say You don't have an abusive partner, just a partner that you're afraid of. Well, what if that partner works for law enforcement and wants to know where you are at all times and uses this exception to get that information from cell phone companies? If it falls to the cell phone company in that scenario to protect your right to privacy, then your right to privacy is protected in that scenario. But if the cell phone company is required to say, this is where that person is, then your right to privacy in that scenario is stripped from you. Or let's say you have told your employer that you're sick, but they find out that you're running around town by asking, I don't know, their cousin who works at the local law enforcement office, where is so-and-so on Thursday, January the 14th. There are a lot of scenarios in which we are very protective of our location. And in all of those scenarios, the United States Supreme Court has recognized a constitutional right to privacy. And we can go further into this if you want, but the right to privacy is rooted in two parts of the Constitution, the 4th and the 14th Amendments. And in both of those recognitions of the right to privacy, if you go through the US Supreme Court jurisprudence discussing the right to privacy, you'll see that it's not a trivial matter where we are at a particular point in time. It's a very important matter, which when it's infringed, we experience a major deprivation of our rights.
Okay, thank you.
Yep.
Representative Thorne?
Thank you, Madam Chair. Mr. Kebeda, what's your current location?
The United States of America. I'm kidding. I'm in Portland, Maine, Mr. Thorne, Representative Thorne.
Thank you. Thank you, Madam Chair.
Sure.
Committee members, any additional questions? Representative Babbage?
Thank you, Madam Chair. Mr. Kebeda, could you specify how, given the liberal wording that has been added, can you specify how this is an expansion?
Sure. So currently, if a law enforcement unit in Maine requests location information from a cell phone company, and the company says, actually, we're not entirely convinced that there's an emergency. Let's say the request was, tell me where so-and-so was on Saturday. And let's say the cell phone company suspects that that request is not motivated by an actual emergency. In that scenario, the cell phone company, for better or for worse, but the cell phone company is protecting your right to privacy, your right to be somewhere without anyone knowing. You have your cell phone, the cell phone company knows that you're there. Law enforcement can find out that you're there if the cell phone company turns over that information. If this bill were passed, the cell phone company would be required to agree with the law enforcement unit's assessment of an emergency. Now, I'm not saying law enforcement units' assessment of emergencies are always wrong. I suspect they're often right. But in those scenarios where they are wrong, then it's important to have a certain level of protection against being found out, your location being discovered. And so that's the difference this bill would make. Now, if there was a widespread issue in Maine, if there were Kelsey Smiths in Maine, if there were cell phone companies in Maine refusing to turn over information, then perhaps this bill would have stronger footing. But as Maine State Police just testified, cell phone companies in Maine are very obliging. They turn over records. I remember testimony from Maine State Police suggesting this bill would have a symbolic impact. The word symbolic was used. I believe that where the right to privacy, the Fourth Amendment constitutional right to privacy, or frankly, any other constitutional right is concerned, symbolic bills are a dangerous path to travel down.
Okay, thank you for that. So I had a question about litigation, and it sounds to me that you're saying that currently in Maine, telecommunications company are responsible, still have a responsibility to protect citizen privacy, despite our current facilitation of warrantless information. So regarding litigation, the passage of this law would actually reduce liability on the part of the telecommunications company. Is that right?
It is, but our concern is not the liability of telecommunications companies, as I'm sure is your concern as well. Our concern are whether the ordinary people of Maine have an actual right to privacy that has meaning, that isn't constantly infringed.
Thank you. And my last one, if you indulge me, Madam Chair, is given the wording that is current Maine law, and given the wording of this proposal, do you have concerns of law enforcement using location for purposes other than expressed in the bill?
Yeah, law enforcement are human beings, just like any of us, and no human being is perfect. Every human being is susceptible to abusing their power, and that includes everyone. And there are stories in Maine, as well as in other states, of law enforcement, unfortunately, misusing the power that has been granted to them. And so we have to be aware of that whenever we grant more power.
All right. Thank you very much. Thank you, Madam Chair.
Representative Moriarty?
Thank you, Madam Chair. Mr. Kebada, one additional thought occurred to me, and the question has in fact already been answered by Gregory Smith, but I want to run it by you all the same. Are you aware of any court in the country that has suppressed evidence on constitutional grounds based upon the disclosure of an electronic communications device?
In fact, the United States Supreme Court case that I mentioned earlier was one such case, the most famous such case.
Well, let me ask, I should modify my question if that's my fault. In circumstances like the ones we're speaking about, an urgent and potentially lethal situation.
Although I'm not personally aware of such cases, there are thousands of courts and hundreds of thousands of cases in the country, and to answer that question would require a significant period of research. And so I'm not personally aware of one. Yeah, but I haven't done the research to answer that question thoroughly, although I'm not personally aware of such cases.
Okay, good. Thank you.
Yeah.
Looks like we are done with our questions for Michael Kebada. Thank you so much for appearing before the committee this morning.
Thank you.
And there's no one who wished to speak neither for nor against. And so with that, we'll close the hearing on LD 1581 and move on to our next hearing this morning. And that is LD 1774, an act clarifying the right to legal representation for individuals subject to guardianship. And this legislation is being presented by our committee co-chair, Representative Harnett, and you can begin whenever you're ready, Representative.
Thank you, Madam Chair, Senator Carney, and esteemed colleagues of the Judiciary Committee. My name is Tom Harnett, and I represent the residents of House District 83, which includes the town of Farmingdale and the city of Gardner. I'm here today to introduce LD 1774, an act clarifying the right to legal representation for individuals subject to guardianship. Under Maine's probate code, an adult subject to guardianship is entitled to choose their own counsel or to seek appointed counsel when there is a case in front of the court to terminate a guardianship. It is unclear, however, whether an adult subject to guardianship can retain counsel to file a petition to terminate their guardianship if they can retain counsel to represent them in a grievance alleging their guardian is breaching a fiduciary or other duty as guardian, or if they retain the ability to retain counsel in other situations outside of the probate court process. This bill would clarify that individuals subject to guardianship retain the right to engage counsel of their choosing without interference from others. This bill would make it explicit that a person subject to guardianship can consult, hire, and/or retain an attorney of their choosing without interference from their guardian or anyone else. It also makes clear that they can communicate with an advocate without interference from their guardian or anyone else. Making the right to retain counsel explicit in the probate court is needed in order to remove the barriers that make accessing the probate court difficult or out of reach for people subject to guardianship. Right now, only people who have an active case in probate court have the right to counsel. There are sometimes insurmountable barriers for people subject to guardianship in Maine. They face barriers to get guardianship termination case into court. They are told that they must fill out complex forms and that they need to pay a filing fee, the latter of which is particularly problematic because frequently guardians have complete control of the person's finances. Establishing the right for a person under guardianship to communicate with an advocate without interference is important because even in cases where there is no malfeasance on the part of the guardian, there are situations in which an individual subject to guardianship does not seek information simply because they do not want to jeopardize the often familial relationship that they may share with the guardian. Individuals subject to guardianship should have the right to privately consult with an advocate about their rights without fear of causing strife or offense to a family member who serves as guardian. I thank you for your time and consideration today. I am happy to answer any questions you may have for me, although you will be hearing from advocates and individuals subject to guardianship with far more knowledge on these subjects than I have. That will include legal advocates and experts on the probate law and Maine's probate code. And even more importantly, you will hear from people with lived experience navigating these challenges. And I know that as a legislator, I find that to be the most powerful type of testimony. Thank you for your time and attention.
Thank you very much, Representative Harnett. And we'll follow our usual process of hearing from proponents, those speaking in favor of the legislation, those speaking against, and then neither for nor against. Before we turn to those folks, though, I wanted to give several committee members an opportunity to introduce themselves. Senator Sanborn, you can go ahead.
Hey, Senator Carney. My name is Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook. And I'm sorry I was a few minutes late this morning.
Thank you. And Representative Sheehan?
Thanks, Madam Chair. And I also apologize for being in and out this morning. My name is Erin Sheehan, and I proudly represent House District 12, which is part of Biddeford.
Thank you. Representative Poirier?
Thank you, Madam Chair. I'm Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
And Representative Evangelos?
Thank you, Madam Chair. Jeffrey Evangelos, House District 91, and I reside in Friendship.
Thank you all. And so now we'll turn to the those who wish to speak on this legislation. It's LD 1774. If you wish to speak in support of the legislation, please raise your electronic hand and keep it raised until you've been brought onto the panel. And I'll just start bringing folks over. We'll first hear from Elizabeth Ward Saxel.
Good morning, Senator Carney, members of the committee. My name is Elizabeth Ward Saxel, and I represent Maine Sexual Assault Support Centers through the Maine Coalition Against Sexual Assault. Thank you so much to Representative Harnett for sponsoring this important bill. Individuals with disabilities experience sexual violence at a much higher rate than those without disabilities. There are lots of stats that are varying, but as many as 83% of females and 32% of males are victims of sexual assault. We also know that even to a greater extent than other survivors, they are assaulted by people they know and trust. Between 97 and 99% of abusers are known and trusted by these survivors, including family members and other caregivers. Also, in part to the victims may be dependent in some way on the person who caused the harm, as sort of previously noted. And also the fact that individuals with disabilities are often not believed. Only 3% of sexual abuse cases involving people with developmental and cognitive disabilities are ever reported, which often leaves individuals with disabilities subject to higher rates of repeat victimization. For example, 50% of women with disabilities who have been sexually assaulted have been sexually assaulted more than 10 times. As a result, it's critical that we provide individuals with disabilities as many paths as possible to disclose sexual violence, to seek support in determining the path they want to address it, and to access legal representation if needed. And we need to make sure that guardians are not a barrier. Many victims of sexual violence do not want to talk about what's happened with them, with someone close to them, which may seem counterintuitive to some. Individuals under guardianship may need to talk through what's happened to them and to discuss their options, and may not be ready to share that information, at least initially, with their guardian. In addition, since we know the vast majority of sexual violence against individuals with disabilities is perpetrated by someone who is known and trusted by them, in the worst case scenario, the guardian may be the person who's causing the harm or has reason to protect the person who's causing the harm. Our providers have been in situations where an individual wanted to have a forensic medical exam, sometimes called the rape kit, done in an ER, only to have a guardian stand in the way of having that exam done and evidence collected, which certainly could be for many reasons. We believe that the right to consult, hire, and or retain an attorney of their choosing, and or to communicate with an advocate without interference from their guardian or anyone else is an important step that this legislature can take to help this abuse come to light and to help protect against repeat victimization. I urge your support of this bill and would be pleased to answer any questions you might have.
Thank you for testifying today. And next, I'm just going to move some people over from the attendee space, and it will take a moment for them to join us. Let's see, Simone Mallon, you may begin your testimony.
You got it.
I've been practicing all night.
I almost told you yesterday that you get another chance today, but thank you. Good morning, Senator Carney and Representative Harnett and honorable members of the Joint Standing Committee on Judiciary. My name is Simone Mallon. I'm the Executive Director of the Consumer Counsel System of Maine. We represent people with mental health lived experience in public policy, including legislative matters. And we're here today to support LD 1774, and we thank Representative Harnett for sponsoring this bill. Many of us in this room, virtual room, may not understand the enormity of what it's like to have somebody who has complete control over you. Think about, you cannot decide where you live, what you get for funds, who your doctors are, what medications you may take. It is the most controlling situation a person could be in. And for this reason, it is highly important to support people to have every available access to them when they need it, for legal guidance or an advocate. Many people do not need a guardian forever. There are many people that work through making decisions and use support to come out of guardianship. And if you cannot access somebody to talk to, and it's for a variety of reasons, and Elizabeth spoke eloquently of many of those, but it doesn't have to necessarily be about abuse or assault. We all need supports in our lives. We all need them to make good decisions. We have friends, family members, all kinds of folks that you and I use on a regular basis, and people under guardianship should have that same access. And so we really want people to be able to make good decisions and make good choices for their lives, whether they stay in guardianship or not, or want a petition to come out of guardianship if that's appropriate. The other reality is most people under guardianship are living in poverty. They're living on Social Security. They don't have the financial resources to obtain an attorney, nor do they know the process maybe to get an attorney. But certainly for financial reasons, that just is not in the realm of possibility. And so I just want to reiterate, we owe the individuals that are living under the most severe restrictions, which guardianship is, every affordable resource to make the best decisions for their lives. So I urge you to support and pass LD 1774, and our fellow peers deserve the very best from us. And I thank you for your time today.
Thank you very much. Committee members, questions for Simone Mallon? I'm not seeing any. We appreciate your testimony today.
Thank you.
Next, we'll hear from Kyle Pelletier.
Thank you, Madam Chair and Harnett, for sponsoring this bill. My name's Kyle Pelletier, and I live in Fort Kent, Maine. And I'm a person that has a disability, and I'm my own guardian. My dad told me when I turned 18 that I would be my own guardian to make decisions on my own. So I'm here to support people that they don't have their guardians, to have a legal right to have an attorney to proceed their process of getting their guardianship. We don't have enough money to actually get a guardian, get a lawyer and to do that. So I'm here to let you guys know that this LD 1774 should be passed, so people with disabilities should be able to have the right to have a legal attorney to proceed with their guardianship. Thank you.
Thank you very much, Kyle Pelletier. Let's see if there are any committee questions for you. Committee members, any questions for Kyle Pelletier? Not seeing any. Thank you once again for testifying today. And next we'll hear from John McGovern.
Thank you, Senator Carney and Representative Harnett and the members of the committee. My name is John McGovern. I am from Bangor, Maine, and I am a person that has guardianship. I believe a person under guardianship has the right to seek legal help without needing the permission of their guardian first. Guardian termination is very complex process, and it needs to be easier for a person under guardianship to seek help from the attorney. If I wanted to terminate my guardianship, I should not have to ask my guardian's permission first before I can work with an attorney. A person under guardianship should always be able to work with an advocate without their guardian getting in the way. A person under guardianship should be able to retain an attorney to help them fill out the legal forms to get in front of the court. Adding the proposed language to this bill would help remove a large barrier and would allow a person under guardianship to more easily access the court system. For this reason, I respectfully ask the committee to pass LG 1774.
Thank you very much, John McGovern. Committee members, are there any questions for John McGovern? Not seeing any. Thank you very much for providing testimony today.
Thank you.
And next we'll hear from Marco Orlando. You may begin when you're ready.
Thank you, Madam Chair. Representative Harnett, distinguished members of the Judiciary Committee. My name is Marco Richard Orlando. I live in the Bangor Brewer area. I am not my own guardian. I don't know how people I don't know how many follow the news regularly, but I've been paying attention to the Britney Spears situation recently, and it's been mind-boggling how one of the most popular artists in the world basically had the same rights as a 10-year-old under a conservatorship. And it made me realize that there are tons of other people in a similar situation who don't have the resources that Britney Spears does. And surprisingly enough, those stories don't start with a public meltdown the way Britney Spears did either. Starts out often as a 17, 18-year-old kid, angry, miserable, trying to survive high school. And they may not understand why their parents are doing what they're doing. Maybe they do, but they trust their parents, so they go along with it. And then the next thing you know, they spend half the day in the courthouse, and a judge makes a ruling that pretty much changes their lives forever. And it leaves a bad taste in their mouths for a while. There's some resentment. They feel robbed of their autonomy. They feel like a non-person in the eyes of the law. And then time passes. They start coming to terms with living with a disability, living with a guardian, living under a guardianship, for instance. Then time passes. Life knocks them around a little bit. They bounce around different groups of friends trying to find their place in the world. Then they experience other successes like taking a driver's ed course, getting their permit, passing the road test, getting their license, enrolling in a bachelor's degree program, taking online classes, doing well with them. But in other aspects of life, they may have some deficits. They may not always know if a part of their body has an infection. They may not know there's anything physically wrong with them until someone asks them questions about it. And it makes them realize, was this the right thing? Did my parents do the right thing doing what they did? And it makes them wonder if something less restrictive like power of attorney might have been more appropriate in that situation. Legal counsel should be an option for someone who isn't their own guardian to be able to challenge it if they so desire. That option should be on the table for them if that's what they decide they want to do. So I encourage the committee to pass LD 1774 for those reasons. Thank you very much for your time. Have a good day.
Thank you, Marco Orlando, for your testimony this morning. Committee members, are there any questions? Not seeing any. We appreciate you being here. And next we'll hear from Stacy Converse.
Good morning, Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. My name is Stacy Converse. I am a managing attorney at Disability Rights Maine. I lead our developmental disabilities program, and I have been doing so for about 13 years. Most of my clients are individuals with developmental disabilities, largely adults, and the vast majority of the individuals I work with are subject to guardianship. So I just wanted to sort of highlight, I submitted testimony, but highlight some of the things. So I guess, first of all, I don't think this is a great leap to put this explicitly in the probate code. I think these rights are already, the right to counsel is sort of buried in there. So there are several provisions in the probate code. People have the right to communicate with others absence of court order. They have a right to choose an attorney. They have the right to court appointed counsel in an active case before the probate code, a probate court, whether that be a termination or that be an initial petition. Taken together, I think this shows that the intention was that people have the right to consult counsel about a potential guardianship case they have. I think what's ironic about that is it took me, so I've been practicing in this area of law again for more than a decade, and it took me sort of a long period of time to go through and pull out the various provisions to see that that right really was in there. And someone who's subject to guardianship, most people aren't going to have the time to do that. And I think it particularly puts people at risk who are subject to guardianship, because the whole issue is whether or not they have access to counsel. And in order to figure out if they have access to counsel, they would have to hire counsel to figure out whether or not they have that right. And even though that right seems to be in there, it is still a little unclear when that right is triggered. So whether that is once someone's in probate court, or is it triggered before? And there are practical problems that exist with the way it's written today and people's access to the courts. So typically when people file any sort of lawsuit, they consult an attorney beforehand, they put their case together, they make strategic decisions about what evidence to submit, how to do it, when to do it, what witnesses to get before you actually file. And so people who are subject to guardianship should have that same right before they file their case. And this is particularly true, I think, in guardianship cases in particular, because people under public guardianship, frequently their guardian is a family member or someone that they care deeply about, and they want to maintain that relationship. So really handling the case in the best possible way to maintain that relationship is important, and getting advice in order to do so is also an important part of that. I think, as Representative Harnett highlighted, there are numerous procedural obstacles to get into probate court if you are trying to terminate or your guardianship or file a grievance against your guardian, including filing a petition, paying a fee, gathering evidence that your guardian has sort of more control over. So you have someone who makes your medical decisions for you, for instance, chooses your medical providers frequently. Oh, I'm almost out of time. Anyway, so I should have timed myself better, but I just want to stress that it's crucially important that this be clearly articulated in the probate code in a separate section that makes it clear to people subject to guardianship and attorneys or advocates that may assist them that individuals do in fact have this right. And I am happy to answer any questions.
Thank you very much. And it looks like we do have a question. Go ahead, Representative Thorne.
Thank you, Madam Chair. Welcome, Attorney Converse. I have one question as a non-attorney. At what point do you, if somebody calls you or contacts you, do you question or ask about whether or not they have a guardian to proceed? Is that intuition or?
No, we do that as part of the intake process. So I will say, I can't remember, I was rambling so many statistics off, but 70% of the people, adults I work with, do have a guardian. It is a question we ask every single person who does an intake with Disability Rights Maine.
Okay, thank you. Thank you, Madam Chair.
You're welcome. Any other questions, committee members? Not seeing any. Once again, thank you for appearing before the committee today.
Thank you.
And next we'll hear from Michael Kebeda. Go ahead.
Thank you, Senator Carney, Representative Harnett, and members of the committee. Hello again. I'm Michael Kebeda. I'm Policy Counsel for the ACLU of Maine. On behalf of our members, we urge you to support this bill because it would help protect the liberty of adults subject to guardianship. An adult subject to guardianship, as you've heard, experiences a very substantial loss of independence and many, if not all, of their rights. Depending on their capacity at the time the guardianship is established, the person subject to guardianship cannot make their own choices about where to live, where to work, what kind of medical care they get, whether they get any medical care, in some cases where they eat and who they spend time with, and still more major decisions. Recognizing this very serious and far-reaching implication of guardianship, Maine law requires probate courts to grant guardianship in a way that ensures that the person subject to guardianship retains, quote, maximum self-determination and independence. This bill would ensure that the self-determination and independence of the person subject to guardianship is zealously guarded. If enacted, this bill would give adults subject to guardianship the right to retain counsel and communicate with other advocates. Currently in Maine probate courts, the only people subject to guardianships who have a right to counsel are those who have an active case. Initiating a case in probate court requires surmounting a series of bureaucratic steps that makes the right to counsel practically inaccessible to many adults who are subject to guardianship. This bill would go a long way in solving that problem. Once in court, the legal requirements for modifying a guardianship pose still more barriers, especially as you heard from Elizabeth Ward Saxel, where the guardian is causing harm to the person subject to guardianship. For these reasons and a few more stated in my written testimony, I urge you to vote ought to pass. This bill would ensure that people subject to guardianship have fundamental rights and liberties that are better protected than currently. Thank you for your time and attention. I'm happy to try to answer questions.
Thank you very much. Committee members, any questions? I'm not seeing any. Thank you for testifying this morning.
Thank you.
And we will next hear from Candy. And Candy, I'm not remembering your last name. Candy Cleaves. Welcome to the Judiciary Committee. You can begin whenever you're ready.
Thank you. Hopefully you guys can understand me well enough. I'm got the joy of dealing with COVID. Good morning, Senator Carney, Representative Harnett, and honorable members of the Joint Standing Committee on Judiciary. My name is Candy Cleaves, and I'm from Garland. I'm speaking in favor of LD 1774, an act of clarifying the rights of legal representation of individuals subject to guardianship. I myself am a person with multiple disabilities, but I'm fortunate enough not to require a guardian at this time. I've had an opportunity through employment, as a volunteer, and as a friend to hear and witness many issues with people being denied what should be basic rights. One situation that stood out to me the most was a woman under guardianship of a non-related guardian. She was a mother. While she does not have custody of her child, she had not had her rights terminated. She wanted to have visits, but the guardian didn't think it was a good idea and did nothing to help her. There are so many issues, to name a few: not being allowed to date, choose to go out dancing in a club, to choose to have an alcoholic drink, the ability to have a late night phone call with a friend, and the right to choose who their own medical care and providers are. These are rights that most of us take for granted. We can do better and we must do better. So please pass LD 1774 so that individuals can have a say in their own lives. Thank you.
Thank you. Committee members, are there any questions for Candy, please? Not seeing any questions. We all hope that you feel better soon.
Thank you.
And then I wanted to turn to those in the attendee portion of the meeting and ask one final time if there's anybody who wishes to speak in favor of this legislation. So Alan Cobo-Lewis, we're going to bring you over to the panel. And you can begin your testimony whenever you're ready. Welcome, and feel free to begin your testimony when you're ready.
Thank you, Madam Chair. Chairman Carney, Chairman Harnett, distinguished members of the committee, my name is Alan Cobo-Lewis. I'm director of the Center for Community Inclusion and Disability Studies at UMaine. CCIDS is Maine's federally funded University Center for Excellence in Developmental Disabilities, or UCED. And I'll skip the boilerplate because I see that there's a timer running. So I'll just say that I'm testifying for myself and for CCIDS as a USED, not for the University of Maine or for the University of Maine system as a whole. In updating probate code on the 128th, this committee adopted supported decision-making into statute and put requirements in place to minimize the use of highly restrictive court actions such as plenary guardianship. Although supported decision-making is an area of ongoing research, it is well established that people with significant disabilities are able to make choices. It is also well established that people with significant disabilities are at heightened risk for abuse. I think you heard some examples of that earlier this morning. Definitely when living in institutional settings, but also unfortunately sometimes when living in a community setting, including with family. The goal of supported decision-making is to ensure that people with intellectual disability have the freedom and tools they need to participate as equal citizens and be free to direct their own life. On the other hand, the goal of guardianship is to achieve protection. While these goals are sometimes perceived to be in conflict, LD 1774 would actually promote both goals. Supported decision-making is something that we all use. This very committee is supported by nonpartisan legislative staff, even as the committee clearly makes its own decisions. I am supported by financial advisors before making retirement account elections. I'm supported by real estate brokers before buying or selling a house. I've hired attorneys and non-attorney advocates to resolve disputes about the education of my child who has a disability and about his disability support services. I have a right to choose my attorney. I also have a right to choose other supporters and non-attorney advocates and to communicate with them. That is the essence of the language proposed in the bill, specifically, I think, lines 12 to 17 of the bill. That even under a guardianship order, an adult subject to guardianship may retain an attorney for any reason, not just pertaining to a guardianship proceeding, and to communicate freely with ombudsman, advocate, court, etc. This bill promotes the rights of a person subject to guardianship to make choices while also protecting them from potential abuse or coercion. And I would urge the committee to support the bill. And I'm happy to answer any questions that you may have.
Thank you, Alan Cobo-Lewis. And could you just remind us of, or please state your town of residence? We didn't catch that at the beginning.
Oh, sorry. I think I was stressed out knowing that you were flashing the timer. I live in Orna.
Thank you very much. Committee members, any questions for Alan Cobo-Lewis? I'm not seeing any. Thank you for testifying today.
Thank you.
And next we'll hear from April Kerr. April, welcome to the committee. And if you can begin by introducing yourself and letting us know where you live, we'd appreciate that.
Can't hear.
Do you want, yeah. Do you have an option other than the headset that you could try perhaps?
Work?
We can hear you loud and clear now.
Oh, wonderful.
And if you can introduce yourself and let us know your place of residence, and then go ahead with your testimony. Thank you.
Sure. My name is April Kerr, and I am in Farmington, Maine, where I live and have for many years now. Here to testify in favor of LD 1774. Just want to start by saying that I know as a driver of an automobile, I like to be in the driver's seat whenever I can. I've had the privilege of having my driver's license for over 35 years and have learned what works best in most situations, in other words, the road conditions and vehicle capabilities, such. However, I've also had my fair share of times when I have rode with others and their ability to navigate the road and weather, etc., were not always the best. In some cases, I might even say it alarmed me greatly to the point of wanting to just get out and find an alternative way home. When you have a guardian, you can't just get out, let's say, and call someone else to, get you where you need to be. It's more like being in an airplane. You're at the mercy of that pilot. They're in control. If turbulence hits and you're wondering, oh boy, how long is this going to be? Where am I going to land? The uncertainty is surmountable. Can you imagine your life being in the hands of someone so much as they are when you get into an airplane? No way to get help or change your mind without the pilot agreeing. If I have to resort to someone taking control in my life and advocating for me, making decisions for me, I would hope that they would have the best interest at heart. But in many cases, this is not how it is. People can be selfish and want things to go their way, even when they are supposed to be acting in the best interest of the individuals that they are to be the guardian for. Can you imagine how much more of a problem it is when it is a company that is the guardian or a family member, as you've heard in some of these other testimonies? Going to someone for permission and or the money to dispute what you don't like about the way they are doing something kind of sounds like a catch-22 to me. You're darned if you do and you're darned if you don't. This is why I strongly agree that people under guardianship should have the ability to access attorneys and or advocates when the situation warrants for such an action. So with that in mind, I urge you to please vote ought to pass. Thank you very much for this time.
Thank you very much for your testimony. There are some questions for you. Representative Thorne, go ahead with your question.
Thank you, Madam Chair. Ms. Kerr, are you here today testifying on behalf of yourself or with the Consumer Counsel System of Maine? Just for clarity.
I'm testifying on behalf of myself. I do volunteer at the Consumer Council many times, and I've had the privilege of meeting many people in the community where I've seen other situations that this would apply to.
Okay, thank you. Thank you, Madam Chair.
Yeah, thank you. And thank you for the additional information, April Kerr. Committee members, any other questions? Not seeing any. We appreciate you being here today.
Thank you.
And the last person here to speak in support of this legislation is Leo Delicata. And if you could begin your testimony.
Thank you, Senator Carney. My name is Leo Delicata. I'm an attorney with Legal Services for the Elderly, and I live in Portland. You've heard what this legislation provides with respect to the help that one can get from an attorney or other advocates. And I agree that all of this is not specifically included in our present probate code. And I'd like to take you through a couple of sections of the code just to indicate what that means. Currently, Section 5-126 of the probate code, which I've attached as page 4 to my testimony, allows an individual subject to a guardianship or conservatorship to file a grievance in writing or other record with the court if they reasonably believe that the guardian is breaching the guardian's fiduciary duty or otherwise acting in a manner inconsistent with the probate code. It does not provide for the appointment of attorney for this purpose. Neither does it expressly allow such an individual to contact an attorney for assistance. That poses a problem for the attorney, and it creates a barrier for the individual seeking help. In the ordinary course, where there is no imminent danger to the individual under guardianship and no statute allowing an attorney to represent, the attorney must normally deal with the guardian instead of the individual. But by definition, the guardian is the subject of the grievance. So it makes no sense to require the attorney to ignore the individual asking for help. And perhaps that's why logic suggests that the right to consult with an attorney is implied in this circumstance, but it's not expressed. Without counsel to assist them in the process, including investigating the facts and presenting them to the court, it's less likely that the court will have the facts necessary to determine whether its original order requires remedial adjustments to the guardians of powers, or whether this information should trigger a more formal proceeding for termination or more drastic modifications. The adoption of the amendment before you would remove a perceived barrier because it would recognize the right to consult with counsel for all reasons. Currently, the only provision that specifically allows all adult individuals to choose an attorney to represent them after the court has appointed a guardian can be found in Title 18C, Section 319, which has been mentioned. This section contains the procedure for termination or modification of a guardianship. Subsection 7 specifically allows the adult to choose an attorney to represent them, and if they don't have one, requires the court to appoint an attorney to represent them. But you don't get to the court unless you can file a petition, and you can't file a petition unless you have the ability to do so. There's another section of the code that provides another reason for supporting the adoption of this proposal. Section 5315 sets out in detail some special limitations on a guardianship's power. Included in these limitations in subsection 3, which I've attached as page 5, and you can read it, but it prohibits a guardian from restricting the rights of an adult under guardianship from communicating, visiting, or interacting with others unless the guardian satisfies some very specific conditions. So that would solve most of the problems that we now have with respect to contacting advocates. However, the prohibition does not apply to a guardian who was appointed prior to September 1st, 2019.
Mr. Delicata, I just wanted to let you know that the 3 minutes is up, and I know that you're covering some very dense information, but if you could wrap up and then we'll turn to committee questions.
Okay, I will read 2 more sentences then.
Thank
Unless
you.
a judge of probate enters an order that binds those prohibitions to a presently excluded guardian, they will remain applicable. They will remain unapplied. Because a great majority of existing guardianships were ordered prior to September 1st, 2019, guardians for perhaps thousands of adults may now believe that they are free to take action to restrict or eliminate contact that the adults under their care may have with other people. So I hope you pass this bill, and I hope you also look at that particular section, section 5315, and bring it up to date. It's been 2 years, and it might not be a good idea to leave those restrictions unapplied to the majority of people who wanted a guardianship. Thank you.
Thank you very much. Representative Thorne, you can go ahead with your question.
Thank you, Madam Chair. Attorney Delicata, thank you for coming and helping clarify this. My question to you is, what's the significance of differentiating between 18 and older versus 18 under 18?
You mean in the probate code? There's a section of the probate code that deals with guardianship for minors, and there's a specific section that deals with guardianships for adults. We deal generally, because our clients are over 60, obviously we deal with the section that deals with guardianship of adults.
So would this bill apply to both under 18 and over 18, or?
I don't believe that you're being asked to amend the minor guardianship statute, but I am unfamiliar with whether the same issues apply for minors, and that is a question for work session. Thank you.
Thank you. Thank you, Madam Chair.
Committee members, any other questions for Leo Delicata? I'm not seeing any. Thank you once again for providing testimony this morning.
Thanks for the opportunity.
At this point, I think we've heard from everybody who wishes to speak in favor of this legislation. So I would ask anybody in the attendee part of the meeting who wishes to speak in opposition to please raise their electronic hand. And I am not seeing anyone. And finally, if there's anybody in the attendee portion of the meeting who wishes to speak neither for nor against, please raise your electronic hand. And again, I am not seeing anyone. And so at this point, we'll close the hearing on LD 1774. Representative Poirier, go ahead.
Thank you, Madam Chair. I just had a quick question before we close it for the bill's sponsor. I just wanted to know if he had reached out to ODES regarding this bill to get their opinion.
I am not familiar with the acronym. I'm sorry, Representative Poirier.
That would be the Office of Aging and Disability Services for the state.
I did not specifically reach out to them, but I can certainly contact them if you would like them at the work session.
That would be really great to get their input on it because obviously they deal with disabilities in adults. That's all they do. So it would be very important for me to have their opinion on this for the work session, and also clarification on whether if this, like Representative Thorne mentioned, if this is just geared towards adults or if it would have an impact on minors as well.
The bill, I believe, is geared only to adults under guardianship, but I'll certainly track that down for you and get in touch with that agency.
Thank you very much.
Thank you.
Thank you, Representative Poirier. And with that, we'll close the work session on LD 1774. We have, close the public hearing. We have two more public hearings this morning. It's almost 11, and I think it makes sense to take a short break. And so if we can all return at 10:55, we'll conclude with our final two public hearings. Thank you. Representative Harnett, do you want me to continue to run a timer for this, the first hearing? Oh, I'm not able to hear you.
You can't hear me because I'm muted. I can, sure, if you want to do it for the first hearing, that'd be great.
Okay,
Thank you.
I will. You're welcome.
We are just waiting for committee members to return so we can conduct our two final public hearings of the day. So as folks return, if they could activate their camera so that I know they are with us. Give just another couple of minutes. Well, we appear to have certainly more than a quorum, and most of our members have returned. I will be running the final two public hearings today. We will begin with LD 1804, which is an act to provide consistency in the laws regarding domestic partners. I will first hear from the bill sponsor. Then I believe we have a co-sponsor, and then follow the regular order of hearing from those in favor, those opposed, and those neither for nor against. I will remind everyone testifying who is not a state representative to please make sure to indicate at the beginning of your testimony where you reside and if you are representing any organization or testifying on behalf of an organization. And unlike my co-chair, I am not as adept at moving people from participant to, from attendee to participant. So I'll be relying on Susan Panett to do that. And I would ask for her to move both Representative Tiffany Roberts and Representative Barb Wood to the panel, to panelist status. As soon as they are here, we will begin the public hearing on LD 1804. And I see that we have been joined by the bill sponsor, Representative Tiffany Roberts. Welcome to the Judiciary Committee, Representative Roberts. And when you are ready, if you could please introduce LD 1804. Thank you.
Absolutely. Good morning, Senator Carney. No, afternoon. No, it's not afternoon. Representative Harnett and distinguished members of the Judiciary Committee. My name is Tiffany Roberts, and I represent House District 6, which includes parts of North Berwick and South Berwick. I am pleased to be here today to introduce LD 1804, an act to provide consistency in the laws regarding domestic partners. In the last session, as House Chair of the Committee on Innovation, Development, Economic Advancement, and Business, the committee worked on legislation that would allow for license reciprocity for members of the military, their spouses, and domestic partners who are coming to Maine from other jurisdictions. During this work, we uncovered a discrepancy in our current laws. We were presented with at least 3 different definitions of domestic partner to parse out and determine which would be the most applicable to the task at hand. Upon further investigation, it was found there were even more instances and definitions. Currently, state laws contain more than a dozen different definitions of domestic partnership, and this lack of consistency has created confusion and ambiguity throughout the statute, which needs to be swiftly remedied. This bill will establish a standardized definition of domestic partner as included in the Maine Uniform Probate Code. It will also replace the assortment of definitions presently used in state laws, limiting the potential for any additional confusion in the future. I want to thank you very much for your time and consideration of my testimony. This bill was drafted by stakeholders' attorneys with the input of your analyst, who will likely be coming after me, that can speak more to the details of the bill, but I'm happy to answer any follow-up questions that the committee may have.
Thank you very much, Representative Roberts, for being here today and introducing this legislation. Are there questions from committee members for the bill sponsor? Seeing none, it looks like you are off the hook for now. Again, thank you very much for coming to the committee today as the bill sponsor. You're welcome to remain as a panelist for the duration of the hearing.
Thank you, Mr. Chair.
And I will now turn to Representative Barb Wood, who is, I believe, a co-sponsor of LD 1804. Welcome to the Judiciary Committee, Representative Wood. Please begin your testimony when you're comfortable. You're muted, Representative Wood. It happens.
It happens too frequently. Good morning, Representative Harnett, Senator Carney, and esteemed members of the Judiciary Committee. I am State Representative Barb Wood, and I represent House District 38, which is the western end of the peninsula in Portland. I'm here today as a co-sponsor of LD 1804, an act to provide consistency in the laws regarding domestic partners. I'd like to share a personal story with the committee. I have been in a domestic partnership for 16 years. 11 years ago, Carol and I became registered domestic partners in the city of Portland. That registration was accepted by my employer, LL Bean, as proof for my domestic partner to be added to my health insurance. Last year, when I was elected to the House of Representatives, I chose to get my health insurance through my new employer, the state of Maine. I submitted my Portland domestic partner registration so that my partner could be added to my health insurance through the state. To my extreme horror, at the 11th hour, I was told that the Portland registration was not valid at the state level. And then I discovered the criteria for the state was slightly different than the criteria that Portland had used. I had to scramble to find new proof of my domestic partnership in order to add Carol to my health insurance. This bill will not fix this issue because this issue was an inconsistency between the state and the city. But I tell you this story as an example of how inconsistencies can cause problems. It just makes sense that LD 1804 be passed to clean up the inconsistencies at the state level. It currently can be confusing and cause issues that impacts people's lives. Thanks for your consideration.
Thank you very much, Representative Wood. Are there questions from committee members for Representative Wood? I see Representative Thorne.
Thank you, Mr. Chair. Representative Wood, help me out. I'm not familiar. What's the difference between domestic partner and spouse and how that applies?
Well, a spouse would be, I don't know the legal definition, but I think it implies that you're married. I am not married. I have a domestic partnership with my partner.
And a follow-up, if I may, Mr. Chair?
Yes, Representative.
Are you able to be married in Maine?
I am legally able to be married.
Okay. So a distinction between domestic partner and marriage is just a formality that they did not recognize in Maine. Am I correct?
Can you ask the question again?
Sure. It's not the first time that's been asked of me. The state of Maine would recognize your partner if you were married, but not that you are a domestic partnership, correct?
Well, it would recognize if I was married, it also recognizes domestic partnership.
Okay.
I just didn't have the consistent domestic partnership registration. The one I had was from Portland. I needed one that was slightly different from the state of Maine. And I was able to make that happen, as I said, at the 11th hour, but it was just that there was an inconsistency between how the city of Portland registers domestic partners and how the state registers domestic partners. As I said, in the end, it all worked out, but it was quite a bit of scrambling at the deadline.
Okay, thank you. Thank you, Mr. Chair.
Thank you, Representative Thorne. Senator Sanborn.
Thank you, Mr. Chair. Representative Wood, I was wondering if you think we should add to this legislation preemptive language that would align any existing municipal definition of domestic partnership with the definition in this statute.
I think it would be great if everyone in the state was treated the same way. I'm not sure, to be honest, whether other municipalities provide domestic partnerships or if you have to go to the state. In Portland, I know that you have the choice to go either direction.
Thank you.
Thank you, Senator Sanborn. Are there additional questions for Representative Wood? I see an indication that Representative Galgay-Reckitt has her hand raised, but I'm not seeing her. Up, I'm not seeing her, but now I do see her. Representative Reckitt.
Thank you. I just wanted to clarify, I think, because I'm in South Portland, and prior to the time I was allowed to be married, I was engaged in a domestic partnership, but it was not registered with the city. I registered with the state. So I think it might be a little wrinkle in Portland, and I don't know if it's a little wrinkle anywhere else, but it might be more simply solved by asking the operation, finding out if it's just Portland, because they were so early to this issue, I think is the reason that there's a discrepancy, because the state published their stuff fairly early, but it was after Portland. So I think that's how the discrepancy started. So I don't know how the best way to solve it, but I don't think you have to do it in a state law, to tell you the truth, but maybe you do. Thank you.
Thank you. Did you have a question, Representative Reckitt?
Well, I guess my question really is to the analyst, probably, as to whether or not you know, or with the sponsor, whether you know that the discrepancy is really an oddity as opposed to the general practice. The difference between the state and the cities, city and towns.
We'll certainly look at that before the work session.
Thank you.
Thank you. Representative Wood, I see you have your hand up. Did you want to respond to that?
Yes, if I could, Mr. Chair. I just want to be clear that I was not presenting today to ask that this be looked at a statewide level. I was just stating an example of how inconsistencies can cause problems, and I'm hoping that the committee can vote ought to pass on 1804.
Thank you. Senator Kine.
Thank you. Representative Wood, I'm looking at some of the other testimony here and wanted to ask your response. Specifically, I was looking at looks like DAFs, and they mention that it amends 24 MRS section 2319A to remove the prohibition against enrolling someone as a domestic partner under a policy less than 12 months after the termination of coverage for a previous domestic partner. So I heard your testimony to be, I thought, more around looking at definitions and aligning definitions, but this would seem to change insurance coverage stipulations. And I think the reason maybe why that was in there, it looks like, if someone is it'd be very difficult to just enroll one person after another as a domestic partner. So I think they were trying to get some sort of time frame put in there. But so that was their comment. I was wondering if you could respond to that for me.
To be honest, Senator, I'm not involved in all the legalese of this. There is somebody else who's going to be speaking who I think is better to answer that question. I think what we're looking for is just consistency in language.
Okay. And all right, they did CC you on this letter, I noticed, which is why I thought maybe you would have looked at that. And who would you recommend I ask that question to?
I believe Mary Bonato is on the panelist list.
Okay, thank you.
You're welcome.
Thank you, Senator Keim, and thank you, Representative Wood. Representative Roberts, I noticed that you were the person copied and the letter just came out today. So I don't know if you had anything to add or if we should just hold that to the work session.
Again, I believe I'm going to second what Representative Wood said, and believe that Ms. Bonato would probably be able to answer it best. But this is to give consistency across the board. In order to do that, there are some definitions that are tied in things that need to be ironed out. Registered was another part that Ms. Canado can speak to. I mean, 18 definitions in statute is a lot for one term.
Perhaps 17 too many.
Maybe, yeah, I think so.
Thank you. Additional questions for the co-sponsor or the bill sponsor? Seeing none, I would turn to the participant room, the attendee room, and ask if there are persons that would like to be heard in support of LD 1804 to please raise your electronic hand and keep it up until I notice you. I know that we were told that Mary Bonato would be testifying. If we could have Ms. Bonato moved over to panelist status, committee clerk, that would be wonderful. And I see that she is here. Good afternoon. Nope, still morning. Good morning, Ms. Bonato, and welcome back to the Judiciary Committee. Please begin your testimony with an introduction of your place of residence, and an organization you might represent. Thank you.
Very good. Thank you so much, Representative Arnett, Senator Carney, distinguished members of this committee. I'm Mary Bonato. I am an attorney. I live in Portland. I work for GLBTQ Legal Advocates and Defenders, known as GLAD. And I'm actually here today testifying on behalf of GLAD, as well as Equality Maine, Maine Transnet, the Maine Women's Lobby, and the ACLU of Maine. And I recognize in the last session and this one that there are a lot of questions about domestic partnership. And part of that is because it's sort of like a Jerusalem where something gets built and then you build on top of it and on top of it. And it's gotten to the point where it's rather cumbersome. There are multiple definitions out there. And so all of our groups are very appreciative of the effort of the sponsor and the co-sponsors in putting this bill forward to streamline and update our laws. I mean, really part of it is also decluttering, because I did count, and I believe there are 18 definitions in addition to other cross-references of domestic partner in the law. And you see three definitions, all three key definitions in operation. One of them derives from 2001 in the first recognition of domestic partnership in Maine, which is from the insurance statutes, where employers really wanted to be able to buy policies, health policies that covered domestic partners and couldn't. And there were comprehensive changes. And this was a time when this was so new and there were lots of requirements put in, including this 12-month requirement, because we didn't know who these people were. What were they going to do? Were they going to be fraudulent? And so there were these kinds of restrictions put in. That's, I think, one thing that happened. And I'll talk about that more in a minute. In addition, 2 years later, this committee actually had lots of hearings, and the legislature ultimately approved the Domestic Partnership Registry, which Representative Wood referred to. And that has a 12-month requirement also. But I would say that going to the probate code definition, which is what this bill is really about, which is something, again, this committee addressed at length in the 128th legislature and updated when you were updating the probate code and you came up with that definition of domestic partner, that one is fantastic because in one sentence, it's comprehensive and concise and gets on issues that we're talking about, two people who have a mutual commitment, who are exclusive. It doesn't do it that way. It sort of sums it all up and looks at their relationship to make sure that it's one of mutual responsibility for over the long term. And that's what we're talking about here, because normally with rights come responsibilities. And that reciprocity, we think, is very, very important. So all of this said, we're very supportive of the idea of decluttering, streamlining, updating, and having that definition in the words and phrases, knowing, of course, that anytime the legislature wants to use a different definition for a particular purpose, of course, it's free to do so. So it doesn't hamstring the legislature in any way, but it would really avoid a lot of confusion and I think help with those who have to administer these laws as well as those who benefit from them. So I actually thought I submitted my testimony this morning, but maybe it didn't happen. And it is up there. So I've provided some information, but I want to address the 12-month issue for a minute, if I may. I mean, one thing I'll just say right off the bat about the registry.
Ms. Bonato, we are on a 3-minute timer and your time's expired. So if you could
Okay,
wrap
then
it
I'm
up. But I bet you might receive a question on the point that you wanted to discuss.
Sure did.
So with that, I would turn to committee members to see if there are any questions for Ms. Bonato. Senator Sanborn.
Good morning, Ms. Bonato. I was just going to ask what you wanted to say with regard to the 12-month provision in health insurance.
Sure. Thank you. What I wanted to say was partly, I believe it's sort of an artifact of the times in terms of just being really suspicious or not knowing, like, who are these people who are going to sign up as domestic partners? And I do think, again, we've going through a lot and learning a lot about who non-marital families are, whether they're different sex or same sex and so on. So there's that. The other thing that I wanted to say is, how does this actually work in practice? And I was thinking about provisions of the bill. I provided some examples here. So the bill addresses updating legislative ethics rules and lobbyist disclosures, which right now are tied to the insurance definition and the 12-month limitation. And I guess I just wanted to ask, like, is it better to have these disclosures only at 12 months and not for the previous 30 days? If there's a concern about a conflict of interest, you would think it would obtain and apply when that relationship has entered, and it should be on people not to sort of be checking the clock, but instead to be thinking about reporting. There's another provision in the bill that talks about business owners who can appear in court on their own, without an attorney, in eviction, detainer proceedings. Again, if you're in a domestic partnership, that one is tied to the registry. So again, you can't do that for 12 months. But if you own a business together and you're domestic partners, it seems like you should be able to do it and not have to wait 12 months. But I do want to speak personally about this for a moment, because I did have, and I put this in the testimony, an acquaintance, somebody who I did see semi-regularly, who had been with her partner for over 20 years. This is at a time when people could not marry. And she woke up one morning to find that her partner had died of a heart attack during the night. And in addition to all the horror, did have to make a call about trying to find a funeral parlor that would take custody of the body. And she was told, no, we cannot do that because we need family to do that. And I will tell you that the number of us advocated on this issue afterwards, and it was addressed, but again, it was addressed with the insurance rule and the 12-month limitation. Now, these people happen to be together over 20 years, but I think that same horror would apply if you've been in a relationship for 6 months and found your partner deceased in the morning. So I do want to just say, like, are the purposes of our laws being served by this 12-month limitation? And again, I didn't update the testimony this morning, but I haven't really seen, so far at least, anybody really making an argument for the 12-month rule. To me, it's a bit of an artifact and actually counterproductive to the policies that this legislature is trying to accomplish.
Thank you, Ms. Bonato. Are there additional questions from committee members for Ms. Bonato? Seeing none, thank you very much for being here, as always. We appreciate your assistance. And with that, you're probably going to be flying back to the attendee room.
Thank you so much.
Thank you. And I will now turn to the attendee room to ask again if there are any persons who wish to testify in favor of LD 1804 to please raise your electronic hand and keep it up. And seeing none, I will then ask if there are any persons in the attendee room.
I'll attempt to be brief because Mr. Marson touched on a lot of the points that I was going to touch on myself.
What was just happening there? I'm sorry. But I do see that we have moved Mr. Austin over to attendees. To panelists. We do not have any persons testifying in opposition, but I believe, Mr. Austin, you are here to testify neither for nor against on behalf of the Maine Hospital Association. Is that correct?
Yes, sir.
Welcome back to the Judiciary Committee. Please begin your testimony when you're comfortable.
Sure. Thank you, Representative Hartnett, members of the committee. My name is Jeff Austin. I'm here on behalf of the Maine Hospital Association. And I hope I don't complicate your lives too much, but we're here to speak neither for nor against, to just raise an issue for you to consider. The standard that you're moving to across all the statutes is one that will have to be applied by businesses like ours all the time. The section of the bill in particular that we're implicated in is section 20 of the bill, which deals with a related issue to what you just heard about disposition of deceased bodies. And so you created in law a hierarchy, spouse and domestic partner are number one, and then adult child, and then parent and others. So you created a hierarchy of who we are supposed to listen to as to how to dispose of remains. The issue that was raised to me in connection with this bill is, while we're not in any way wedded is a funny term to use here, committed to the standard that's here, which is the insurance standard, the 12-month versus 9-month versus 6-month, we don't care. But it is a clear test for our folks to apply evenly across the board. The definition you're giving us isn't a test-based definition. And so there's consistency across the law is a great goal. Our fear is if you give us a definition that's amorphous or ambiguous, each institution has to come up with how to determine that the standard that you're giving us has been met. They might have a 5-part test. They might have a 3-part test. There's nothing to prevent them from using, as far as I can tell, the current insurance code test as the way they reach the answer to the question, does this domestic partner have a long-term arrangement that evidences a commitment? How do we have to come up with a way to apply this in our policies every day to the extent this comes up. And how they do it, I'm afraid, and our members are afraid, is going to be inconsistent. One's going to say, oh, we use the registry. If you're registered, that's how we answer the question. Are you two unmarried adults who are domiciled together under long-term arrangements? Somebody else, another hospital may say, oh no, we're putting into our policy the old insurance 5-part test. This is bureaucracy to us. I don't care if it's a 12-month standard or a 9-month standard or a 6-month standard, but a clear, in the real world, we have to apply it clearly and consistently. And I'm afraid we won't because it's so amorphous. For purposes of probate, where you have a judge who's used to weighing evidence and looking at multiple pieces of evidence to come to a conclusion, the more amorphous standard might make sense. For us, it's kind of a bureaucracy. We're trying to get through this. So I'm not sure you're going to accomplish consistency.
It's right. My farm is right on the water. If people across the river.
Thank you.
Yes, one hospital on this side of the river might have an application that a different hospital across the river. That's kind of our point. So it's almost like we don't really care. We'll leave it to the experts what what a good standard is and what a fair standard is and what an equitable standard is. But if you give us kind of an amorphous definition, which I think is what we're getting, please don't be surprised if different regulated entities apply it differently in the real world. That's our comment. And so I'm sorry to complicate your morning, because psychologically, I love it when you try to clean up statutes and inconsistent definitions. I think it appeals to my psychological makeup, but you're sacrificing one form of consistency for another. Now, on the question of who's a domestic partner for purposes of disposing of a body, different facilities may answer that question differently, because they've got to somehow figure out what questions to ask in order to answer the more amorphous definition you're giving us, if that makes sense. I'm sorry. With that, I'd be happy to take any questions.
Thank you, Mr. Austin. And I will call on people in the order that I saw their hands come up, beginning with Senator Sanborn.
Thank you, Mr. Chair. Mr. Austin, my understanding of what we would be repealing with regard to the insurance definition is the prohibition on having on replacing one domestic partner with another within a 12-month period, which I think, as Ms. Bonato explained, is sort of a historic artifact of a concern that this would be abused or fraudulently used in order to get health insurance for people's friends through their employer, which certainly has not been an issue and is unlikely to become one because other evidence is needed in order to show that the relationship between the two people is real. So a waiting period is not something we've ever needed in marriage. You don't have to wait. You can get married the day after you get divorced. And so I'd love to have you comment a little bit on that issue of a waiting period, being needed for the disposal of remains, and why you think there needs to be sort of some bright line test of any length as to what sort of waiting period has to be established before one domestic partner could be substituted for another.
Right. I'm not sure if that's a second issue in the insurance code. I really don't know. I'm just looking at section
Year and never heard back. I apologize.
Section 20 of the bill, and it doesn't. I mean, yes, in subsection B, there's the 12-month. We don't care. Make it 9 months. Make it 6 months. Make it 30 days. It's a clear standard, one that we can ask. Have you been domiciled together for 12 months? Yes, no. So if you want to get rid of B in section 20 of the bill, which is Title 22, Section 2843, subpart A, okay. But if you look at this, but that is the insurance code definition. That's why I brought up insurance code. We don't need necessarily a 12-month waiting period. Actually, that's actually a policy question for you, because if you were to look at the full statute that's listed under section 20, what you have is one subpart. What it says is, in deciding who can determine the disposition of remains, it goes in order. It is a pecking order. 1 and 1A are spouse, domestic partner. Then it's adult child. Then it's parent, I believe. And then it's sibling, I believe. So that's a policy question for you. Our members won't care. The only way it comes up is if there's a dispute, right? Everything's fine until it's not fine. We just want somebody to tell us, which funeral home are we sending the body to? Where it potentially comes up for a policy question for you guys is, let's say you have an adult child who disputes with the domestic partner. That's the policy question for you. Should the domestic partner have been in a domicile together for a year before they get to decide before the adult child? Let's say you made it 30 days. That's a policy question for you. We don't care. If you want to let a domestic partner who's been domiciled with the deceased for 30 days to decide where the body goes in front of an adult child, so be it. But that's for you to weigh all those things. All I'm saying is our person at the hospital who works for the hospital who has to make this decision is going to turn to the lawyers and say, okay, and so what our members do is they write policies. They write hospital policies.
360 dimensions.
And so our lawyers for each of these hospitals will be writing the policy that says, this is how we determine whether or not an individual who claims to be a domestic partner under Maine's definition, how we determine that they are. And then I don't know how each hospital is going to write that policy. Some may say, we just go off the registry. It's cleanest and easiest. Are you registered? There's nothing to prohibit that. Another hospital may say, we're just going to write right back into the hospital policies the insurance definition. We know of no other way to answer this question. Two unmarried adults who are domiciled together under long-term arrangements that evidence a commitment to remain responsible indefinitely for each other's welfare. A probate court might be used to that. Our guys kind of just want. So it doesn't have to be the insurance standard. I know I'm being a jerk here. We don't care what the clean bureaucratic standard is, but if you don't give us a clean bureaucratic standard, I'm saying you're shifting that task to each regulated entity to craft their own, and you will get inconsistency. And when your policy goal was consistency. So you're going to have uniformity of definition, but if the definition is a bit amorphous, you might not get consistency in application. Sorry, somebody raised this to me. I'm just the messenger. And so one other issue, if I may, real quick, because I promised Peter Gore, who's not going to testify, he can't be here. He said, you might want to hold off on changing the Family Medical Leave Act definition because there's a lot of work going on in the Labor Committee. I think, as you know, your colleague is running a bill to make it a paid family leave bill. I think they're running a actuarial study on it right now using the definition of domestic partner that's in the Family Medical Leave statute, which you're changing here. But Peter wanted me to pass that along. That's what he was going to raise to you. So in addition to our concern, which is we each have to come up with our own test now, which we can do, but I'm not sure that they will do it consistently is all.
Thank you. Does that conclude your questioning, Senator Sanborn? Senator Keim.
Well, thank you for offering this perspective, Mr. Austin. It's really helpful. So my question is just, okay, so in this scenario, you talked about a body, but wouldn't we also run into that same situation if we're in a hospital room and the person is incapacitated and we have a disagreement about who's going to be making the medical decisions for that person in that moment as well, right?
Yeah, there are a few different areas where we're implicated. There's donation of organs, organ donor statute is in here. There's a few different places where this where we run into this, where we have to make a decision. Who speaks for the patient?
And so currently, the idea of someone just being registered is not, because you said they have the option to choose that route right now, but as far as you're aware, the hospitals are not. They're just basically asking them how long they've lived together.
We don't have that choice now. We have to go based on whatever statute we're under. So for the body disposition statute, it's the insurance code. For others of our statutes, a lot of you can see Title 22. I don't think all of these are ours. Some of these are funeral home. You look at around here, all the Title 22 stuff, typically it's registered. So no, we don't have a choice. That's what the law says. Are you registered? Yes or no? What I'm saying is if you get rid of those crisp and clean standards and give us this more holistic one, and there may be a lot of great reasons to use a more holistic one, but if you give us one that's a little gooier, when our compliance officers go to write the hospital policy, they have to make the GUI a little bit more concrete
Right,
and give frontline
understood.
people, here are the 3 questions we ask, or here are the 4 documents we request. And
Thank you. Yeah, very helpful. Thank you so much.
Thank you, Senator Kime. Representative Thorne, I saw you had your hand up before. Have your questions been answered? You're okay? Thank you very much. Are there other questions from committee members for Mr. Austin? Seeing none, thank you very much for coming before the committee today. Always a pleasure to see you. No, you don't have to apologize. You're doing your job. I will turn back to the participant room to ask if there's any other person, I'm sorry, the attendee room, to ask if there's any other person who would like to be heard on LD 1804. Please raise your hand. And I see that person. So if you could, if the committee clerk could please move Mr. Gore over to the panel, to panelist status. And as soon as he is here.
Good morning, surprise.
Mr. Gore, welcome back to the Judiciary Committee. Please begin your testimony with an introduction and the organization you represent when you're comfortable. Thank you.
I am ready, Representative. Good morning, Senator Carney, Representative Harnett, members of the Joint Standing Committee on Judiciary. I am Peter Gore. I'm the Executive Vice President of the Maine State Chamber of Commerce. I want to thank Jeff for speaking. I didn't think I was going to be able to be here this morning. I rearranged some things because I do think this is important for us to be on the record. To be clear, we don't have an issue with creating a single definition across all the different statutes. This is actually a policy issue that I've been involved with for a while, since it was first taken up in the health insurance side. Although honestly, that happened a long time ago and I don't remember all the intricacies of it. But our issues echo Mr. Austin's issues, in the sense that we're fine with a single definition as long as it's easily understood, it's clear, and it's easy for employers to apply. And this, unfortunately, this current definition, the proposed definition, we have concerns doesn't do that. And as a consequence, as Mr. Austin indicated, it will be applied differently by different employers in different circumstances. And I don't think that's what you're looking for. And there are examples, and some of these definitions that have been in the statute, has been pointed out, have been there a long time, and there are reasons that they were very succinct. And some of those reasons, some of the different distinctions, it may be time to eliminate them or alter them. But clarity of those distinctions and definitions is very important. And as Mr. Austin indicated, our primary concern is around the change that's proposed in Title 26 in Section 843. That deals with the Family Medical Leave Law and the definition of domestic partner in the employment law statute. It's very clear for an employer to look and see who qualifies. The current definition, I think, will be confusing. And with confusion often comes litigation, which I think we all want to try and avoid. In addition, as you know, the Paid Family Medical Leave Commission has been conducting its meetings for the past few months and are working towards developing a proposal that they will send to an actuary to price out to determine uptake, eligibility, benefits, cost, payment structures. And they've been working towards doing that and putting ideas out there. And this definition is the definition they're currently considering. I mean, there's a broader policy discussion that has to take place around paid FMLA leave in terms of who ultimately is going to qualify and how. But right now, this would be the definition they'd be using, not the other one. And I don't know what the impact would be on their work and on costs with a broader definition as proposed in this particular piece of legislation. So with that, I'll end my testimony. I thank you for your time. I apologize for my informality of dress today. Like I said, I didn't think I was going to make it in time. And I appreciate the opportunity to provide you with our comments.
Thank you, Mr. Gore. Thank you for being here today. I see we have two folks with hands raised. I will begin with Senator Kime, followed by Representative Thorne. Senator Kime.
Thank you. Nice to see you, Mr. Gore. I was wondering if you could provide your comments in written form for us.
Sure, I'll be glad to do that.
Thank you.
Thank you, Senator Kime. Thank you, Mr. Gore. Representative Thorne.
Thank you, Mr. Chair. Mr. Gore, I didn't hear you specify, just for clarity, are you testifying neither for nor against on this bill?
Yes, sir, I am.
Okay, thank you.
Thank you, Representative Thorne. Are there additional questions from committee members? Seeing none, thank you for attending today's hearing, Mr. Gore. Always a pleasure to see you. I will now take a final tour of the attendee room. See if there's anybody else who wants to be heard on LD 1804. Please raise your electronic hand. Seeing none, I will close the public hearing on LD 1804, thanking the bill sponsor for bringing it forward to the Judiciary Committee today and to everybody who testified. I'm sorry, but I see Representative Babich has a hand up. I missed that.
That's fine. It's actually a request, or maybe for a clarification of the analyst. When we talk about registration of domestic partners, is that merely for financial reasons, insurance, maybe taxation? And when registered, I'm looking at section 20 of the bill. Are those criteria part of the registration process? I'm trying to.
Can I provide that? I'll pull the law about registered domestic partners, which was enacted prior to the marriage law being broadened to not prohibit same-sex marriage. So the registered partners predate that. And so I'll bring you the state requirements for registry, and then we can look at how that applies.
Yes, I guess what I'm asking is, does the registration process provide specificity that is the subject of our discussion in the last 20 minutes? Thank you.
Thank you, Representative Babich. And unless I see other hands within the next 5 seconds, I will now, for a second time, close the public hearing on LD 1804. And again, thank everybody who participated today. We have one bill left. It is 20 to 12. I feel that looking at the number of people that are signed up to testify, we may be able to get through this quickly. So I would like, unless there is strong opposition from committee members, to continue with the public hearing rather than take a break now, so that we can wrap up our day's work as quickly as possible. Is there anybody who has any concerns or problems with that? Seeing none, I won't wait for any more time. I will then open the public hearing on LD 1786. LD 1786 is an act to maintain consistency among Maine's non-discrimination statutes. I welcome the bill sponsor, Senator Carney, and when I turn to testimony of others, I will be keeping the clock, and I will let people testifying know when they're approaching the end of their 3 minutes. Senator Carney, welcome to your committee. Please proceed with the introduction of your bill when you're comfortable.
Thank you, and good morning, Representative Harnett and esteemed members of the Judiciary Committee. As you know, I'm Senator Ann Carney, representing Senate District 29, which includes South Portland, Cape Elizabeth, and part of Scarborough. Today, I'm pleased to introduce LD 1786, an act to maintain consistency among Maine's non-discrimination statutes. In the first regular session of this legislature, we passed and enacted a different bill, LD 1688, an act to improve consistency within the Maine Human Rights Act, to address consistencies within Maine's primary non-discrimination law. Originally enacted in 1971, the Maine Human Rights Act had accumulated many internal inconsistencies as it was amended over time. The legislation enacted in the first session made the Maine Human Rights Act clearer for the public and easier for Maine courts to interpret. The bill before the committee this session, LD 1786, focuses on the laws outside of the Maine Human Rights Act. There are many inconsistencies, between the Maine Human Rights Act and other laws that prevent discrimination. In fact, Maine statutes include 25 non-discrimination provisions outside of the Human Rights Act that were not updated when 1688 became law. As a result, these 25 provisions use outdated language that predates and is not consistent with the non-discrimination language and protected classes currently contained in the Human Rights Act. For example, Maine's Civil Service Code of Fair Practices and Affirmative Action states complaints of discrimination based on race, color, religious creed, sex, national origin, age, physical handicap, or mental handicap should be made to the Maine Human Rights Commission. So that statute is referring to those matters within the jurisdiction of the commission. However, the Maine Human Rights Act no longer uses words like religious creed and handicap. Instead, the act refers to religion and disability. Additionally, the Maine Human Rights Act expands the list of protected classes to include ancestry, gender identity and expression, and sexual orientation. In order to fully protect Maine people from discrimination, we must use clear, consistent language in all our statutes. This will provide consistent protection for all Mainers. It will help state and county and municipal bodies understand the law better. It will give businesses one clear set of rules to follow, and it will help our courts apply the law by creating consistent legal standards. Inconsistent and outdated language creates confusion and uncertainty for everyone. Thank you for your time and attention, and I'm happy to answer any questions you may have.
Thank you very much, Senator Carney, and thank you for bringing LD 1786 forward to the committee. Are there questions from committee members for the bill's sponsor? Seeing none, again, I thank you very much for your time in introducing the bill today, Senator Carney.
Thank you. And Chair Harnett, can I just make one other remark? I would just like to thank our committee analyst for the excellent chart that she prepared summarizing the changes proposed by the legislation.
So noted. Thank you very much for that work, Peggy. I will now turn to persons testifying in support in favor of LD 1786. The only person I have signed up to do that is Quinn Gormley. Quinn, welcome back to the Judiciary Committee today. Please begin your testimony when you're comfortable with an introduction of yourself and any agency that you might represent. And remember that you will be on a 3-minute clock after the introduction, and I'll hold up the time when you have about 20 seconds left. Okay?
Thank you very much, Representative Harnett and esteemed members of the Judiciary Committee. I believe this bill is quite straightforward, and I will keep my comments brief today. My name is Quinn Gormley. I'm the Executive Director of the Maine Transgender Network, and I'm presenting testimony today on behalf of Maine's LGBTQ+ Policy Coalition, which includes Maine Transnet, as well as GLAAD, Equality Maine, the Maine Women's Lobby, and the ACLU of Maine. Together, we are in favor of LD 1786, an act to maintain consistency among Maine's non-discrimination statutes. LD 1786 is a simple, straightforward bill. It ensures that throughout Maine law, we will use language consistent with the Maine Human Rights Act when addressing discrimination on the basis of actual or perceived race, color, sex, sexual orientation, gender identity, physical or mental disability, religion, ancestry, or national origin, age, or familiar status. This ensures these explicit protections extend to such areas as state agency hiring and contracting practices, jury service, access to financial assistance programs, and candidacy for office. This consistency reflects hard work done by this committee in recent years, work that is supported by the majority of Mainers, to ensure our non-discrimination laws reflect current best language and practices for achieving a safe, fair, and just system of protections for all Mainers. We're also create clarity and consistency, which is good for Mainers as well as for people who seek to abide by or enforce our laws. Passage of this bill would see that work extended to our other non-discrimination protections, so that no matter who we are, we know discrimination is not the main way, sending a clear message about the will of Maine's people that we favor a state where all are welcome. Thank you for this consideration. of this bill, and we're happy to answer any questions that you may have.
Thank you very much for your testimony today, Quinn. Are there questions from committee members? Senator Sanborn.
Thank you for being here. My question relates to the provisions of the bill related to insurance underwriting. And I noted that right now in insurance, particularly life insurance and auto insurance, sex is actually used as a category for charging people differently. And I was wondering if you were familiar with any states that had, other states that had banned that practice, and or sort of experience with how insurers deal with transgender or gender non-binary individuals in those areas of insurance where sex is still used for rating purposes.
Yeah, thank you. That's an excellent question. I'm not sure at the moment how other states have handled that, but I would be happy to provide the committee with information on that in advance of your work session. And I imagine some of the other testimony you'll hear today are relevant to some of these insurance questions. And I suspect that there's a solution that is mutually satisfactory to that we could find in the work session.
Thanks very much. Any additional information, that would be wonderful.
Thank you. Are there additional questions from committee members for Quinn Gormley? Seeing none, thank you very much for testifying today. We look forward to seeing you at the work session, and you'll be moved back into the attendee status. But thank you for being here today. I will now turn to the attendee room and ask for people who wish to testify in support of LD 1786 to keep their electronic hand up, and I will get to those in the other categories when we're through with that. The only hand that I see is that of Whitney Parrish. If we could have Whitney Parrish moved into panelist status, that would be wonderful. So we'll wait until that happens. And good morning, Whitney. Very nice to see you again before the Judiciary Committee. When you are comfortable, please begin your testimony with an introduction and the agency that you or organization that you represent. Thank you.
Thank you, Chair Harnett, and good morning, Senator Carney, Representative Harnett, and honorable members of the Joint Standing Committee on Judiciary. My name is Whitney Parrish, and I'm the Acting Executive Director of the Permanent Commission on the Status of Racial, Indigenous, and Tribal Populations. I do reside in Augusta, Maine. I am honored to offer testimony in support of LD 1786, and we extend deep gratitude to Chair Ann Carney for introducing this bill. The Permanent Commission is an independent entity with a mission to examine racial disparities across Maine and to work toward improving the status and outcomes for currently and historically disadvantaged racial, Indigenous, and tribal populations. Further, the Permanent Commission is empowered by state law to advise and consult all three branches of government. Simply but importantly, this bill updates the language, as you've heard, in Maine law to reflect the reality of all people in need of these protections today. Specifically, it will ensure language consistent with the Maine Human Rights Act, prohibiting discrimination on the basis of actual or perceived race, color, sex, sexual orientation, gender identity, physical and mental disability, religion, ancestry, national origin, age, or familial status, as you have heard. Across our races, backgrounds, and genders, we all want to be treated with dignity and respect, and to have protections applied consistently across the board. Some people do try to get and hold on to power by putting us in boxes based on what we look like, where we're from, or our genders. By passing LD 1786, we'll honor the voice of voters who time and again have decided Maine won't discriminate and have this consistent across Maine's other non-discrimination protections and statutes. With this, we believe we can begin to ensure each one of us has the freedom to be ourselves, pursue our dreams, and have a good life with no exceptions. Thank you for your time and consideration of this vital issue, and we respectfully urge you to support this bill. I'm happy to take questions or provide additional information if desired. Thank you.
Thank you very much. Are there questions from committee members for Whitney Parrish based on her testimony today? Seeing none, thank you again for being here.
Thank you.
We appreciate your presence. I will now turn to the participant room to just confirm before moving to other categories. Are there any persons in the attendee room who would like to testify in support of LD 1786? Seeing no electronic hands, I will turn to people who wish to testify in opposition to LD 1786. And I see that we have two persons, one who has already been moved over as a panelist, Rory Whalen, and then we have Penny Morell. And I would ask the committee clerk to move Penny Morell over to panelist status and turn to Rory Whalen to welcome him to the Judiciary Committee. I don't know if we've seen you here before, but thank you for being here. And when you are ready, please begin your testimony with an introduction of yourself and the organization that you represent. Thank you.
Thank you, Mr. Chairman, distinguished members of the committee. I do hope to meet you all in person as soon as that's possible. And I thank you for this opportunity today. I am Rory Whalen. I'm the Regional Vice President of the National Association of Mutual Insurance Companies. I will submit written testimony subsequent to today, along with a white paper from my organization and a recent study from the Insurance Institute for Highway Safety. My remarks are specific to Section 18, and Senator Sanborn, I hope I can shed some light on your question regarding gender and insurance. No single factor accurately measures the totality of risk represented by an individual consumer. It's very simple. The more factors you use, the more accurate the picture of the risk becomes. In reviewing the use of a factor, data is analyzed to determine its potential correlation with risk. And insurers, above all else, insurers want to be accurate. They want to be accurate when they're assessing risk. Why? Because in today's hyper-competitive marketplace, just look at your TV tonight, you see all the commercials from auto insurers. They compete for potential policyholders by offering lower rates, better coverage than their competitors. Each insurer uses its own risk-based techniques that often result in different prices for the same consumer, right? That's the competitive marketplace. More risk-based factors mean that consumers have more choices when it comes to insurance. And risk factors also ensure fairness, and consumers who present a lower risk pay less and they don't subsidize higher risk drivers. It's the essence of insurance. But let's be clear about one thing, and I think is very important about this bill. No insurer ever considers factors like race, ethnicity, national origin, religion, income, or literacy, period. Those factors are not used by any insurer. Now, insurers, as I said, will vary in terms of what factors they do use, but none of those factors are used. Now, while the most prevailing factors that are used have to do with your driving record, claims history, type of vehicle, or in the case of homeowners, size of your home, there are other factors that they use, such as gender identity, and age. So I want to talk about that briefly. I do commend the sponsor for her intent to strengthen Maine's non-discrimination laws. I think that's something that I can't imagine anyone would disagree with. But I do want to point out that the consequence of this law and in banning age and gender will actually treat the most vulnerable and lower income segment of our population unfairly, namely young female drivers. Here are the facts. And gentlemen, I apologize, but the facts are the facts. Men are more likely to engage in risky behaviors.
Mr. Whalen, Mr. Whalen, we have a 3-minute timer and you've exceeded the time. So if you could wrap up, please.
80% of speeding crashes involve at least one male driver. 80% of all DWIs are committed by men. Likewise, men have more seatbelt violations. They drive bigger, more expensive cars with larger engines. And in fact, twice the number of men die in crashes as women. 71% of car crash deaths last year were men. Thus, the population most hurt by removing gender from underwriting factors is women between the ages of 16 and 25. There are other segments of the population that are impacted, but again, removing this factor will actually, I think, is really antithetical to the purpose, which is non-discrimination.
Thank you.
And I thank you for this opportunity.
And some of the information that you want to get out may come out through questioning as well, but we do try to stick to the 3 minutes.
Thank you, sir.
And I would now ask if there are questions from committee members for Rory Whalen, and I will turn to Senator Sanborn.
Thank you, Rory Whalen. My question is it's the same question that I asked the previous speaker about whether there are states that have prohibited rating in auto insurance based on gender or based on sex, I should say, and then to ask how auto insurers deal with gender non-binary or various gender identities in enrolling new customers.
Both very good questions. To your first question, there are just a few states, Hawaii, Massachusetts, Pennsylvania, North Carolina, and California that do prohibit it. And one other state, Montana, had prohibited it, but last year they reversed that law because of what they experienced, and that was that female drivers, especially young drivers, were really paying higher rates than necessary. How do the insurers deal with it? It's just that. People will pay more. You will have a less accurate risk assessment when you remove factors like gender. And I hope that answers your question. I'm happy to elaborate. I do want to be mindful of your time. So in terms of your second question, insurers will generally, if like in Maine, you can put X as gender on your driver's license, they will default to the lower rate. So if there's a rate for it, you assess that person and you run it with a male factor and a female factor, whatever factor produces the lower rate is what the insurer will produce.
Thank you, Rory. Does that end your questioning, Senator Sanborn?
I think I just have one more follow-up, which is,
sure.
Is the gender marker on the driver's license the determining factor that that insurers would look to?
No, I believe, Senator, it would be the application for insurance.
Okay, so they would look to whatever the person self-identifies as in the gender box on the application for insurance.
Correct.
Okay, thank you.
Thank you, Senator Sanborn. Are there additional questions from committee members? Senator Carney and then Representative Babich. Senator Carney.
I don't have a question, and as Bill's sponsor, I don't think I'm allowed to ask them, but I wanted to thank Mr. Whalen for the information. I think it'll help us hone in on a better approach as we go into the work session on this. Thank you.
Thank you, Senator. We'd be delighted to work together to help you pass this bill.
Thank you, Senator Carney, and I will note that you did not ask a question. Thank you. Representative Babich.
Thank you. I haven't refreshed in a while, but I I would ask Mr. Whalen if he would be willing to submit written testimony.
Oh, yes, sir. This afternoon.
Okay, thank you.
Thank you, Representative Babich. Are there additional questions from committee members? Seeing none, thank you very much for your time and the information you provided today. And we look forward to meeting you in person when things return to what we used to call normal. Thank you.
As do I. Thank you very much.
I will now turn to the next person who has signed up to testify in opposition to LD 1786, who has already been moved into the panelist room. And welcome back to the Judiciary Committee, Penny Morell. I hope I got that right. I have a 50-50 shot and I get it wrong most of the time. But welcome, and please begin your testimony when comfortable.
Thank you. Congratulations, Representative Harnett. You did it correctly. Most people call me Morell, but you called me Morell, and that's correct. Appreciate that. Senator Carney, Representative Harnett, and members of the Judiciary Committee, thank you for the opportunity to appear before you today. I'm Penny Morell, State Director of Concerned Women for America of Maine, speaking for Concerned Women for America Legislative Action Committee. Concerned Women for America is the largest public policy women's organization in the nation, with hundreds of thousands of members across the country. CWA of Maine opposes LD 1786, an act to maintain consistency among Maine's non-discrimination studies. CWA has been on the front line opposing gender identity ideology that denies the need to protect women in women's shelters and prisons. It rejects equal rights to female-only facilities and sports teams. It declares war on the very essence of what it means to be female. Gender identity ideology also denies children the truth about themselves as boys and girls, sowing confusion in their minds and deception about their bodies, which is leading to experimental, irreversible medical interventions in the name of gender dysphoria treatment that damages natural development and long-term health. We realize this bill is adding perceived to all scenarios of discrimination in the law with the intent to be consistent in all. However, it adds yet another dimension to an already egregious law. CWA believes this perceived addition to the discrimination laws is arbitrary and an overreach of government's jurisdiction. It can be abused and further tie the hands of individuals' rights to make decisions in their own best interests. This bill is a bridge too far. I ask this committee to vote LD 1786 ought to not to pass. Thank you, and thank you for your service. I'm happy to take any questions and remind you that we are the group that prays for you daily and sends you postcards of encouragement, and we do appreciate each one of you.
Thank you very much. Are there questions from committee members for Penny Morell? Seeing none, thank you. Seeing none, thank you very much for your testimony. I'm going back to the attendee room and seeing if there are any persons who wish to testify in opposition to the bill. Please raise your electronic hand. Seeing none, I will turn to our final category, and that is persons who are testifying neither for nor against. And I would ask the committee clerk to please move Bruce Garrity over as a panelist. And we will hear his testimony when he arrives. Welcome back to the Judiciary Committee. Bruce, please begin your testimony with a brief introduction as soon as you are comfortable.
Thank you, Representative. Senator Carney, Representative Harnett. My name is Bruce Garrity. I practice law in Augusta, and I'm here on behalf of APCIA, which is the American Property Casualty Insurance Association. It is the largest insurance association for property casualty in America. Its members write the majority of business in Maine, including domestic insurers, and there are some 1,200 members. Our concern is only with section 18 of the legislation, which deals with rating. Let me start by saying that we historically in Maine have always recognized the validity of appropriate discrimination. And I'd ask the committee, when you have an opportunity to look at section 2382 of the insurance code, and I'd be happy to reduce these comments to writing if it will assist the committee representative. Section 2382 basically tells us that rates cannot be excessive. You can't charge too much. They cannot be inadequate because that affects a company's capitalization. And the third category is you cannot engage in unfair discrimination. Discrimination is not only allowed, but in appropriate contexts, it's a positive factor. Simple example, 17-year-old boys are going to pay more for insurance on an automobile than a 40-year-old man or woman. And there are actuarial reasons to support that, which I don't need to go into because you've already heard them. It is the same with sex. It is the same with marital status. People who are married, whether it is a same-sex marriage or not, the record reflects and the data reflects that they are less likely to be problematic as insureds. So for that reason, their rates are lower. I will say this, Maine has the lowest or second lowest auto rates in the country year in and year out. It's a statistic I've pointed out many times to different committees. To the extent that you remove the categories that I've just expressed concern about, you are going to charge other people who would get a lower rate more money to make up for subsidizing the higher cost rate, which in my simple example is 17-year-olds. I'd make one other point for the committee's consideration. If you look again at section 2902 capital G, thank you, Representative, that is a provision in the insurance code that specifically requires discrimination on behalf of elderly citizens. We've put into play a provision that says they get an automatic discount if they meet certain circumstances. So we not only recognize these rating characteristics, we promote them depending on the situation. And with that, Representative, I'd be happy to try and answer any questions the committee might have.
Thank you very much for your testimony today, and the committee would appreciate you putting it into writing and submitting it through the clerk and analyst. Thank you.
Will do.
Thank you. Are there questions from committee members? Senator Carney, I know it's not a question, so you may proceed.
Yeah, a quick thanks again for helping us amend this to make sure that we are achieving the intended purpose.
Thanks for having me.
Thank you, Senator Carney. Are there additional or are there any questions for Bruce Garrity? Senator Sanborn.
Mr. Garrity, we've talked about this a lot in our committee, but I note that physical and mental disability is also included as a prohibited rating factor. And I just wondered if you could speak a little bit in the context of life insurance as to why that might be problematic.
Well, let me start by saying that I don't do life as much as I do property casualty and health. To the extent that there are factors out there, and disability can be one of them, that are going to affect a person's lifespan, and there are actuarial data to support that, that's a factor that would be considered along with many other factors by any insurer. And without going into detail on different disabilities or problems, I think people can understand that an individual with a particular serious illness or disability is going to be in a different position than someone who doesn't have a problem. Which is why I think I said this Representative Harnett, but what we're asking the committee to actually do is delete section 18 from the bill, because we think the current system and rankings are appropriate.
Thank you. Are there additional questions from committee members? Seeing none, thank you very much for your time today. We greatly appreciate your presence and the information that you provided.
Thank you.
I will now take a final tour through the attendee room to make sure I have not missed anyone. If there are any other persons who would like to be heard on LD 1786, I would ask you to please raise your electronic hand. And seeing none, I will then close the public hearing on LD 1786. I thank the bill sponsor, my co-chair, Senator Carney, and all those who provided testimony and assistance to the committee today, and to the committee members. And with that, I will close our work for the day. Thank you for going past noon, but look at the beautiful afternoon you have to enjoy under gray clouds and cool weather. So thank you all for your time today. We will be back with confirmation hearings beginning, I believe, at 9 o'clock next Tuesday. Enjoy the weekend and your observance of Dr. Martin Luther King Day. And thank you very much to our staff. Take care.
Goodbye all.